talking a little bit about why more than 100 civil society organizations, international ones, have jointly organized this event here in Mexico. And what are the organizations, some of them that belong to this group, and why we have chosen Mexico this time to be the main venue. First of all, more than 100 civil society organizations, international ones. Some of them are formed by the International Lawyers Institution, also the Institute of Human Rights, of the International Association of Lawyers and Jurists, and also the Progressive Lawyers Association. We have decided every year to hold an international conference to celebrate the importance of guaranteeing the due process in every country. And for this, we have chosen some countries that, according to the organization that are part of this consortium, we believe that it is important to call the attention of international authorities in terms of the importance to guarantee due process and access to justice in every country. Before providing a little bit more of detail about this conference and why we have chosen Mexico, I would like to first of all thank not only all of your presence and attendance, but also in particular the presence of my colleagues, Monica Gonzalez. She's the director of the Legal Institute, and she has lent these facilities, and she has carried out everything having to do with the logistics. Also, Mr. Paulita Fernandez, he's president of the National School of Lawyers in Mexico. I would like to say particularly that this effort wouldn't have been possible without the decisive support of all of our Mexican colleagues that made this event possible and that have provided an exceptional support. Besides this, School of Law and the UNAM's Legal Research Institute, I would like to thank also the IBHRI and the General Council of Mexican Advocacy. So thank you very much. Additionally, I would like to discuss some of the reasons of this international conference. And I would also like to tell a little bit about the agenda that we have for today and the granting of Ebru Timtik award ceremony that will be done this afternoon. Why have we chosen Mexico this year? Well, as I said at the beginning of my introduction, the different civil society organizations that are part of this consortium that are established by the Fair Trial International Day have called for the attention of international authorities, but also the international community on the importance of protecting the right to due process and access to justice for everyone, particularly both defendant in judicial processes as well as the victims of human rights violations. In this sense, Mexico is going through a very complex situation in terms of serious human rights violations, and this is why we will have a panel that will be reflecting on the need for accountability, particularly in cases of forced disappearances and extrajudicial executions. But there are also challenges to guarantee due process and judicial independence in the country. And it is very important to have a judge that's independent and partial, as well as independent public prosecution office to guarantee the rights of every person involved in a judicial process. And that's why it is so necessary for organizations to call for the attention of the international community and authorities on the importance to respect and protect legal independence and due process in every country. Additionally, there are many challenges surrounding, for example, the concept of preventive jailing by law that violates certain international laws. So we expect Mexican authorities to abide with the Inter-American Human Rights Institution that have been declared on the matter. And this brings us to show that the organizing committee of this conference would like to call the attention on the importance to guarantee due process, judicial independence, the rights of victims in judicial processes. And that's why we wanted to contribute by celebrating, by holding this international conference that we are broadcasting online and that's being followed in different countries. And with this, I would like to mention that the program is structured as follows. After these opening remarks, we will be having a panel, and we will be having the honor of the president of Esmeralda Arosamena. She's the commissioner from the Human Rights Inter-American Commission, and she will be addressing different topics surrounding the need to guarantee due process in the framework of inter-American standards in this matter. We will also have the presence, distinguished presence of the president. Well, not it's going to be a video of the president of the Human Rights American Court president. Unfortunately, he couldn't be with us in person today because the court is in session, and we also have a message by the special rapporteur of the Human Rights Magistrate and Lawyers Independent Association, Margaret Stutterwaite. We will also be having a panel where we will be analyzing the different systematic challenges to systematize the process in Mexico. Afterwards, we will be talking to members of civil society on the relevance of guaranteeing due process as a core element to guarantee human rights also in the country. And at the end of this afternoon, we will be having a specific panel on the need of accountability for serious human rights violations, particularly extrajudicial executions and forced disappearances. And last but not least, we will be handing the Ebru Timtik Award, and we will be talking about who Ebru Timtik was. I would like to say, as a matter of introduction, that she was a Turkish woman that defended human rights in her country, particularly due process, and that defended the cause of most vulnerable people in her country. Unfortunately, she was arrested in the framework of an increasing authoritarian regime in her country, and she did a hunger strike as a consequence of this, and unfortunately, she passed away. In her honor, organizations that I represent in this opening statement, we decided to create the Ebru Timtik Award in her honor, also as a mechanism to recognize the defense of human rights that so many people work on around the world. And this year, we will be granting this award to a Mexican person, a Mexican individual. I cannot tell you who that person will be, but that's going to be in the afternoon, and we will be having a special ceremony for this. So with this, I would like to thank all of you for joining us, both in person as well as online. And I would like to pass the floor to my colleagues for the formal opening. Thank you so much. Thank you so much, Monica. Thank you, Carolina. I would like to thank the Institute of Legal Investigation for this international type of event. If you go over the website on the Fair Trial International Day, you will realize how many organizations, international organizations, participate in this effort, talking, discussing, and conveying the importance that having a legal due process has, and having the right conditions within a country in order to solve legal actions, applying the respect on human rights. I would like to very particularly thank UNAM for having welcomed us today, and I would also like to thank our colleagues from the IBAHRI. And with this, we have met one of the goals that we have as the General Council of Lawyership, which is interrelating with international organizations to talk about what's going on in our country, and in order to internationally discuss what's going on in terms of justice rendering and in terms of human rights. I would also like to thank the sponsorship of Eluber Traductores for helping us with the simultaneous interpretation that's being done for those of us joining us in the auditorium, as well as everyone that's following us via Zoom and digital media. I would also like to thank the National Committee of the International Lawyers Union for the work that they've been doing in preparing and organizing this topic and this session. It is an honor for me as a president of the IBHRI to work in favor of the spreading of due process, human rights, its dissemination. We should always be very aware of what's going on in our country, the ghost of populism that's haunting not only our region, but also appearing in different parts of the world. One of the first topics that he always wants to be addressed is for court houses that are free and expedite to stop existing, for them to solve any actions, illegal actions, that so that they can be solved amongst particular institutions. And without any further ado, I would like to thank you once again. Dr. Gonzalez Control, thank you so much for being our host. So we will continue with the formal opening of this event. Good morning, everyone. It is, on behalf of the Legal Investigation Institute, it is a true honor to host this important event that will bring us to the reflection of on a very important topic, human rights, and specifically a right to a fair trial. So I would like to welcome Arturo Pablita Fernandez, President of the Lawyers and National Culture Lawyers of Mexico, and Carolina Villadiego Burbano, leader of the Latin American team of the Juris International Commission, that have also organize this important day of reflection. The right to a fair trial or due process are the set of conditions that ensure the defense of individual rights and the obligations of the state when someone is under a judicial process, what forces it to act in an impartial and rational way. In democratic administrations, this is not only applied to legal process, but also anybody that exercises any investigational affairs. So this finds an important connection with the violations of equal rights before the law and access to an independent and impartial court trial. So we have to, this cannot only represent a word, but it has to be a common asset, and together it has to constitute only one right, which is the right of everyone to an access without any discretionality, discrimination, or any arbitration. The right to a fair trial is stipulated in a huge number of constitutions around the world. It is about the basic fundamentals of the human rights constitution that was adopted in 1948, and that our Mexican constitution collects in articles 14, 16, 19, and 20. Some basic principles are necessary so that a trial is fair. We have first the right to communication, the right to a lawyer, the right to be heard by an independent, impartial, and competent trial, the right to a public audience, the right to be considered innocent until proven otherwise, and evidence has to be shown via evidence has to be shown in order to be found guilty, and the right to a defense, and the right to be heard in a reasonable time, the right to be present in the trial, the right to also call for witnesses to be cross-examined, the right of having an interpreter, and the right to have a sentence. So in many countries, fair trials are not always a reality. So among the reasons, we have the weakness of the legal system and insufficient lawyers or judges that are not well trained, as well as a lot of work in public defense institutions. Also, people do not know their rights, which of course gives a stage to arbitrary trials. So judges, of course, see a challenge within this. These challenges are not old ones, nor sorry, they are not new, and they are not far from disappear. They are far from disappearing. They bring us to think about the fights that we should be starting, just as Ebru Timtik did. It proves that the systematic use of the state apparatus against people could produce the worst consequences and violations of human rights, such as the human right to life. Ebru Timtik, Turkish lawyer, was condemned to 13 years for supposedly belonging to a terrorist group, and she started a Congress strike demanding a fair trial after a polemic trial. There was a lack of access to evidence, and the courthouse didn't accept fair witnesses. So today we are fighting to address these challenges, honoring those who gave their lives for the fight of human rights. Thank you very much, and I would like to bid success to all of these reflection sessions.
Distinguished speakers, participants, and guests, ladies and gentlemen, good morning. My name is Kat Kent, and I am a program lawyer at the International Bar Association's Human Rights Institute. It is my great honor to introduce today's keynote speakers from the Inter-American and international human rights systems. Our first speaker is Commissioner Esmeralda Arozmena de Trotino of the Inter-American Commission of Human Rights. She has served in such position since 2016, including as president during 2019. She was re-elected by the General Assembly of the OAS during its 49th regular period of sessions for a further 4-year term from 2020 to 2023. Commissioner Arozmena de Trotino held office in Panama's judiciary. She was a justice of the Supreme Court, of which she was vice president. She also presided over the Chamber for Criminal Cases and was a judge on the High Court on Children and Adolescent Affairs. She participated in the special commission that proposed constitutional reforms in Panama in 2011, and on the commission that elaborated the Code of Constitutional Procedures in 2016. She is an academic and a professor at the University of Panama, the Superior Judicial Institute, and Panama's Judicial Authority. She collaborates with the School of the Public Prosecutor's Office with regards to the new criminal system and on the subject of juvenile criminal justice. Commissioner, the floor is yours.
Muchísimas gracias.
Thank you very much. Good morning, everyone. I would like to, first of all, convey my recognition to all of the organizations that have organized this important event. This event that, due to its international nature, has brought us to think in the important commitment that represents for the entire world, for the entire citizenships of our countries, the right to have justice, the right to a fair trial. I would like to also recognize the Legally Research Institute. I feel at home here because it is a place where, well, from the Human Rights Inter-American Commission, we have been able to establish contact, a liaison, a very direct liaison with the academia, with the institutions, with the victims, with professionals, with Mexican professionals in all of its grandeur, to know, for the knowledge of the Human Rights Inter-American Commission. We have had that opportunity to participate every year in the important Fix a Moody event. Thank you so much for that opportunity, because this is a place that also ensures a continuity. People that come to these institutions just go by, however, institutions remain. And it is important to ensure that they remain, and we do this along with the amazing UNAM. In this event that I'm going to be sharing online with my colleagues from the panel, the first trial of this from the Inter-American point of view, has a vision, and this vision means warranting. This mission means promoting a strong institutionality in the justice system, but the justice system has to be understood not only in the field of judges, but also the entire structure, the entire stakeholders and actors that are involved in the development of a process. As the first vice president today in the Inter-American Commission, but more than that, acting as a rapporteur for my country in Mexico, and I've been holding this position for almost 7 years, this has allowed me to have a direct contact in a permanent way with the work and the efforts that have been carried out by the Mexican country to improve their justice system as a key aspect. This effort, and I can attest to this, we attribute them to a political will by the state. However, we have to add that this effort in improving the justice system is attributed to the dignifying fight that victims have had, their family members, and all of the human rights organizations that accompany them. So civil society organizations as well that are committed to defending human rights. This right to defend rights. I would like to highlight that in this fight, all of these actions have been led towards a search for a transformation that in many aspects, even today, calls for the transformation of the situation of impunity that the facts that constitute serious violations to human rights find themselves into. Since 2014, in Mexico, great expectations happen in this idea. The creation of the General Prosecution Office, the enforcement of a new legal system, new criminal system, and the public knowledge of acts of obstruction of justice in the framework of the Ayotzinapa case. And I will be discussing it later on in detail. The efforts in eliminating torture as a question mark, among other circumstances that aim to change the face of justice in this country. Even so, along with these events that show the relevance of the work of victims and their family members and organizations on the impunity that's still a reality, a first order reality, a very serious one in the country. It is for justice a very serious situation. This information that I, as a commission, can collect on behalf of the civil society today tells that out of 94% of the crimes committed in Mexico, 94% are not denounced. And there's a probability of only 1% that a crime committed can be solved. This is a truly difficult number to say. The explanations that would allow us to explain this situation just are over right itself. However, this cannot assume that the legal system is not fulfilling a role in this critical situation. This has to be bear in mind. In Inter-American Commission, we have a standard, a very simple standard that is used a lot, and it is highly powerful. I'm talking about Article 8 of the American Convention that establishes the guarantees of due process. Yes, it is a standard that, due to the way it was formulated, it has a sense of protection that we have always read, that we have always interpreted as targeting a person that needs a defense, the person that has the defendant. So I want to I would like to invite you to think about this standard as a warranty for victims of violations of human rights. That's how it has been said today in the different interventions that happened during the introduction. So, it's a legal process. There has to be a proper legal process that checks all of these elements, principles, characteristics that distinguishes what we call a due process. It's going to be the right one, and it has to be the proper one, and it has to be against those people that are involved in the facts, the perpetrators of violations, but it also constitutes a warranty of justice, of effective justice for victims, for their families. And it is, and the true protection will be the restitution of the right that has been violated. This would be a fair trial. It is a warranty that has to irradiate the entire process. And it used to be said that it is not only the legal system itself involved, it's the entire environment or sphere where decision making is done and where conflicts have to be solved. And in the case of the justice system, this warranty that has to irradiate throughout the entire process has to exist to reivindicate, to remediate human rights violations. The warranties of a fair trial are not only responsibilities of courthouses, but they also have to be applied to all of the authorities, all of researching authorities, and the bodies of the inter-American system, the court and the commission, have interpreted that way, that have interpreted Article 8 in this way. So when we talk about justice, we should not only observe the outcome of a ruling, but also the entire process of evidence submission and investigation lines, that they have to be right ones, they have to be timely to propose a theory of the case so that they reach and allow the sanction of those responsible and the satisfaction of victims. A fair trial also means that victims and their family members could send their evidence to those ministerial authorities as well as the judicial ones. This means that their voices have to be heard in real terms, in effective terms, and not only as a mere formality. In Mexico, laws and jurisprudence warranty this right for the victims. However, unfortunately, in many cases, victims and their families have to litigate for many, many years. So the prosecution has to allow them to present their evidence. And the excessive dilations in investigations have to stop. The irregularities have to stop. Just as it happened, for example, in the case of the murder of Digna Ochoa, defender, and her family members now have a ruling by the Inter-American Court. But how much time had to go by? How much emotional wearing had to happen to exercise that right of the access to justice?
Now, this commission maintains a specific mechanism to supervise the Ayotzinapa case file, and I ask for your permission to pinpoint some specific elements in this case. I've had the honor to preside. I've been the chair of that mechanism. Now, there's the forced disappearance of 43 students in this case file from that rural school for professors. Now, that case makes us think today, or rethink today, which are the limits, which are the borders of law. In the case file of Ayotzinapa, it's unique, right? Especially when it's about, in it, we're talking about justice for the victims and those of the victims who have disappeared till today. I mean, they have the right to be object of a search. They're going to be looked at for by their families, and we were looking for the guilty perpetrators or parties, and they were object of torture, and there was that process, and it discriminated, and there we're finding the authors of that crime that was perpetrated, and all this was done under the lead of the prosecutors authorities or aides that examined these people or stakeholders. They obtained their testimonials under torture, which has been dismissed. Those because that's what mandates us in, you know, in the fight against torture. So they obtained those testimonies, and that cannot be presented before the authorities as an exhibit in any court or between a trial. Now, the burden of proof and the exhibits in this case were really devastating. Now, in due process or the proceedings and along the lines of investigation, some data, some years were lost, valuable years were lost amidst this case because there was no conformity or compliance that respected the guarantees of these people amidst the due process or fair trial, amidst the investigations. I mean, there was no correct examination or cross-examination or defense that could have proven the commitment of the authorities to face and materialize through their actions what justice is. Now in this present, the case of Ayotzinapa leads us to observe it under a different glass. Now, I gave you this example because I think it's necessary for us to ask ourselves in Mexico, how many other cases like the Ayotzinapa case are still are hidden? How many violations to human rights are still pending justice? How many cases have led us to a final formal resolution? And there's lies in these cases. I mean, that affects the stakeholders or parties involved and their responsibilities. Who incriminated innocent people along the way? How much time do the victims have to wait if they've been subject of violations of their human rights? You know, through a fair trial that respects the rights, we could shed some redress and repair the damage. We can see through a fair trial in that horizon how they can reconcile with the stories of their life. And, you know, we think about a fair trial, and that guarantees impunity and defenses against impunity. It's not just an abstract value, it's our mandate. We protect human rights. The economies, the nations have to eradicate impunity and guarantee to the citizenship that access to justice. And access to justice for the victims. They have to impose sanctions to the perpetrators, to the active subjects, according to the limits or boundaries that the democratic models and societies have. So we have to ask ourselves, what happens first? What's born first, corruption or impunity? The response is something that we have to assess. Each one of us has to assess those concepts or constructs in each country. That's part of our task. We have to think not only about the criminal justice system and trying to reach a high level of perfection in the implementation of law. I know that in Mexico since 2014, there's been a lot of progress, but today we have to be completely on board and engaged to go through the transformation of what's culturally happening amidst impunity, what's happening with the police forces, the prosecutors, the coroners, the forensic aides, the police forces, as I've said, the military authorities as well, which are stakeholders that end up being a part of the branch that operates and administrates justice, even if they function at an individual level or collegiate bodies. But if we add on our efforts, we can strengthen and protect the citizenship of Mexico who have been victimized and who have been affected in their basic human rights. We all want justice, and they deserve justice as human beings and citizens of this nation. Thank you so much.
Thank you so much, Commissioner, for your really powerful remarks. So actually convey the vision of the Inter-American Commission and the need to promote strong institutionality to improve the justice system and to ensure justice and accountability for human rights violations within the context of and relation to the right to a fair trial. On behalf of the steering group, we are really delighted and truly honored you accepted the invitation to join us in person today. It means a great deal to us, so thank you so much. We turn now to our second keynote speech by Judge Ricardo Perez Manrique, President of the Inter-American Court of Human Rights. He is a Uruguayan lawyer who has served as the president of the Inter-American Court since January 2022. Previously, he was a judge of the court itself and a minister of the Supreme Court of Justice in Uruguay. In 1973, he graduated from the Universidad de la República with the degree of Doctor in Law and Social Science. In 1974, he revalidated his degree at the Universidad de Buenos Aires, practicing law in Argentina. In 1989, he entered the judiciary in Uruguay, where he had a long career. He was appointed Minister of the Supreme Court of Justice in Uruguay in 2012. Please can we kindly play Judge Perez Manrique's video message.
Dearest Luz Helena, Commissioner of the Inter-American, the volume's way too low, sorry. Disculpen. No podemos escuchar al ponente. For me, it's an honor to participate during this important conference. During the day in which we celebrate fair trial in Mexico that has been organized by the bar now and many associations, this is essential and deterministic. We must have access to justice, and definitely this will enable us to fight for human rights, for the human rights to be material, factual, under fair trial amidst a due process. That's core. Those are core elements in human rights. So we need to be highly deterministic too. And it's for the prevalence also of democracy. The objectives of there's 17 Millennium Goals. We have many goals established. In 2015, we want to face the urgent challenges that our planet faces and foster sustainable development at a global scale. We want to protect our planet and guarantee that we can all prosper. As a core objective, we want to achieve this by 2030. Our clear goals are peace, solid institutions. We want to develop peaceful societies that include everyone and administrate justice for everyone with efficiency. These objectives are tightly linked with the work of the Inter-American Court and the system of human rights. Our objectives are fundamentally to protect human rights. Now, the Inter-American Court plays a crucial role when administrating justice in our institutions. Through its rulings, we have developed a justice system that leads us to protect human rights in our economies. Now, in that sense, the work of the Inter-American Court is fundamental to achieve the objectives, because justice and the strengthening of our institutions are necessary conditions to develop our systems with peace and harmony. Now, having the access to justice is something that we find in Articles 8 and 25 in the Inter-American Convention of Human Rights. From the first ruling in that trial, of Mr. Candela versus Honduras, the court in its ruling specified that the ratifying countries of the Inter-American system have to go through a fair trial to protect the victim whose rights have been violated. In Article 25 of our declaration, in compliance with the enacted law, we use as reference Article 8 of our convention in the general guarantee. That's in the corpus of the convention. in Article 8. We have to exercise the law in our specific jurisdictions. Now we go to Article 1st. In Article 8, we have the guarantee to a fair trial or due process. Article 25th leads us to have the protection of the with a proper defense. We must consider that it's not enough to have. We need to have the right rights and resources to find a remedy to concretely administrate justice. Now, that's what's been informed. So it's fundamental based on case law that's sourced from the Inter-American Court. We know that in the first cases, okay, we have the state and there's court rulings. We need to fundamentally be in compliance with the law through the institutional apparatus so all the individuals can have access to a fair trial. Now, the states involved have to, well, eliminate any constraining situations that do not enable the person to have access to justice. So this translates into being capable of guaranteeing the administration of justice according to the convention. We have a system that guarantees the proper exercise, and we try to ensure that those who are about to be imposed a sanction, I mean, they should not be object of any arbitrary decision. So this is all about the due process and fair trial that was specified in Article 5th, Section 51 of that ruling. Now, along these lines, in Article 8th of our convention, we establish which are the specific guarantees under the fair trial and due process. Now, the court specifies that if there's a criminal court or criminal case filed, there's a specific scope and the rights of the parties involved. In other words, the Inter-American Convention, in the body of law, we have all the rights of the defendants and the stakeholders involved to go through the due process and court proceedings. The hearing must be public. There should be a collegiate body and the different stakeholders that submit or issue the resolutions. So Article 8 of our convention specifies that yes, it's the judiciary branch and it has to react as it must. Which are the new challenges? Challenges when trying to have access to justice. This is all part of our debate. Besides, we know that there's progress in the protection of our human rights, but there's also in parallel many challenges. We must be persistent and fight discrimination and fight social exclusion. There's many efforts that have been material in past decades. We're fighting discrimination. We're fighting discrimination due to gender, religion, disabilities. Now, these situations are still a reality. Another major challenge that we have had to face when trying to protect human rights, it's amidst globalization and the development of technology, we're trying to protect human rights, and there's a lot of progress in this field. So there's many elements that are correlatable or coexist. There's also human trafficking and other crimes that we have to fight in our ratifying states. We need the proper mechanisms that lead us to protect our citizenship's human rights amidst this context. Pardon, I'm having some audio issues. So our society, you know, in different fields has to work. We have to work to protect our human rights and have our people have access to justice, you know. We know that there's risks, simultaneous risks, but we understand that there's needs. We have used, for example, artificial intelligence as well we're regulating artificial intelligence, so we're in compliance with our principles of ethics. We're building the legal constructs that make it possible for us to defend human rights. Okay, so I think that another challenge is having just or environmental protection. I must also mention there's the Kazu Treaty, and who signed off this treaty in correlation to the rulings of the Inter-American Court. We know that there's harmony between the laws, and we have to provide all of the information and law that protects our environment when there's predatory activity in our woods and safe havens. We need to have also or build the right channels to have proper access to the information. As a conclusion, the inter-American system has faced its challenges when trying to protect human rights. There's been a lot of progress in this field, but there's elements that hinder our activities. And the exercise of a right sometimes is not. We need to understand which are the opportunities that we have. So we have to protect those who are vulnerable. The economies must guarantee that all their citizens have access to justice, and the victims whose rights have been violated must be object of a redress, or remedial actions. So with a due process and fair trial through the judiciary branch, we can study the challenges that we're facing in human rights, not only at a regional scale, at an international scale. So I wish you have a beautiful day of hard work, and thank you very much.
Many thanks to Judge Perez Manrique for his pertinent insights on access to justice, the role of the Inter-American Court in promotion and protection of human rights, in particular, of course, the right to a fair trial, and corresponding state obligations in this regard. We turn now to our third and final keynote speech by Professor Margaret Satterthwaite, United Nations Special Rapporteur on the Independence of Judges and Lawyers. She was appointed as Special Rapporteur by the UN Human Rights Council in October 2022. She is an international human rights scholar and practitioner with decades of experience in the field. She is a professor of clinical law at New York University School of Law, where she directs the Global Justice Clinic and serves as faculty director of the Robert and Helen Bernstein Institute for Human Rights and the Center for Human Rights and Global Justice. Her scholarship has focused on access to justice, legal empowerment, and methodological innovation in human rights, among other topics, and she's published several edited volumes and dozens of articles and book chapters. Professor Satterthwaite has worked with individuals and communities seeking to realize their rights around the world, and has litigated in international and domestic fora, including the Inter-American Commission on Human Rights and the African Commission on Human and People's Rights. Can we please kindly play Professor Satterthwaite's video message?
Your honors, dear colleagues, I am pleased to address you at the International Fair Trial Day Conference. I want to thank the organizing committee for the honor of this invitation. The right to a fair trial is central to the protection of all other human rights. Without fair trial guarantees, a powerful leader can put his or her opponents in jail and silence would-be critics with threats of the same. Article 14 of the International Covenant on Civil and Political Rights protects this right by insisting on a fair public hearing by a competent, independent, and impartial tribunal established by law, and making clear that this right applies to both criminal and civil trials. We live in a time when the right to a fair trial is increasingly at risk. The World Justice Project reports that 2022 was the 5th year in a row that the rule of law declined in most countries, with checks on government power falling in 58% of countries, and respect for core human rights and freedoms falling in 2/3 of the countries. We have seen a trend toward democratic backsliding and rising authoritarianism worldwide. Powerful actors have a strong interest in capturing and weakening systems that would otherwise provide a check on their power. As a result, the right to a fair trial is violated in all regions of the world today, sometimes systematically, sometimes in relation to specific groups of people, and sometimes sporadically. Let me tell you about a few of the cases I've acted on since I took my mandate in November of 2022. I've recently addressed my deep concerns to China for the impact that the national security legislation, the ordinance on the legal profession, and the banning of foreign lawyers from proceedings in Hong Kong may have on the right to a fair trial. I have written to Belarus concerning provisions that allow for trials in absentia and the deprivation of citizenship of Belarusians abroad. I have shared my concerns about the anti-terrorism legislation in Sri Lanka, which does not have effective judicial oversight, and where the lack of access to counsel may facilitate the misuse of this legislation. And I've deplored the extension again and again of the state of emergency in El Salvador, as well as the amendments to the Penal Code to address gang violence, where more than 67,000 people are detained, and allegations of serious restrictions to due process guarantees for them, including the use of mass hearings and dramatically inadequate access to defense counsel, continue. There are many more examples. Let me recall that both judges and lawyers have special responsibilities to ensure the right to a fair trial is respected. Judges must be vigilant to ensure the due process rights of those charged with crimes are respected, but the rights of all, even those who are the targets of discrimination, stigma, or bias, are able to vindicate their rights equally in suits at law. Lawyers must zealously defend their clients' interests, advancing their due process rights without respect to the popularity or disfavor with which their client may be held. And both the bench and the bar must work to ensure the independence of each profession is protected. Without such independence, the right to a fair trial withers quickly. Finally, I'd like to emphasize that the very people who are excluded from the protection of legal systems, who experience unfair trials and face unjust sentences and decisions, have valuable insights and knowledge for those running these systems. These communities know what is not working, and often why, in a way that those of us who work within the system may sometimes miss. By listening to those bearing the brunt of injustice, from groups experiencing discrimination to survivors of heinous crimes like torture, we can focus in on the things that need to change. Therefore, I hope we will all listen for those voices as well. A conference like today's is crucial in gathering the energy of the bar and the bench to protect the right to a fair trial in every country. I wish you well in your important work at this meeting. Thank you.
With many thanks to the Special Rapporteur for her important remarks, including on the responsibilities of judges and lawyers, and the need for the independence of the bench and the bar to ensure that the right to a fair trial is ensured and respected. This concludes the keynote speeches. I now pass the floor for the first session on setting the scene, systematic fair trial rights concerns in Mexico. Thank you so much.
Gracias a todos por su presencia, gracias al comité organizador.
I would like to thank the organizing committee. It is a privilege to be with you, sharing all of this opportunity. A brief reminder, there will be some sessions throughout the day that will be in English or in another language. So I would like to remind all of you that we have simultaneous interpretation services so that you can hear it in Spanish. I think in this panel, we won't have any English speakers. However, there will be others. So I just wanted to remind you of that. So our panel is on the systemic problems to protect and warranty the right to a fair trial in Mexico. And for this, it is an honor to introduce the panelists. To my right, I have Laurence Pantin, coordinator of the Transparency Program in Justice from Mexico Evalúa. She is a doctor in political sciences by the Latin American Faculty of Social Sciences. She has a master's in journalism by the New York University, NYU. She has a degree in communication by the Institute of Political Studies in Paris. And her investigation lines are in the judicial independence, judicial government, judicial career, transparency, fighting corruption in the judicial branch, state judicial branches, and digital justice. The floor is all yours. Sorry, I'm going to introduce all of the panelists. Pedro, welcome. Dr. Pedro Salazar Ugarte is a full-time researcher at the Institute of Legal Research at UNAM. So you are home. Thank you for inviting us. Professor of the Faculty of Law. He's the secretary of the Mexican Academy of Sciences and former director of the Institute of Legal Research Institute in UNAM. Thank you very much. So we will start with Laurence, please. Thank you very much. I'm so sorry for having things my way. Well, first of all, I would like to thank the organizing committee of the International Day on the Fair Trial, particularly the International Association of Jurists and Carolina Villadiego for the invitation. Thank you for inviting me to participate in a relevant event, and today it is more relevant than ever. And in order to start with my presentation, I would like to illustrate some of the problems that we face, or that, that Mexican people face in order to respect our right to a fair trial. And I would like to address a specific example, a very recent one. The case of Veracruz judge Angélica Sánchez Hernández. She was arrested last Monday while she was driving to the State Court of Justice, where the president of that institution asked her to join her to explain her resolutions. The resolution was the non-binding of process of a supposed responsible of a homicide. He had obtained a writ of amparo before a federal court. It ordered the local judge to postpone the process to take into account some evidences that were not considered before. The governor, Cuitlagua Garcia in Veracruz, publicly declared that the resolution of the judge was suspicious. To say the least, it was strange because she had been arrested. Then some days before, the governor accused the judge to act along with the lawyer of the defendant to leave this person free. However, the media revealed that the arrest happened because when she was driving the courthouse, the tribunal, she took a forbidden road and she started firing at the police with an army exclusive weapon, and when they neutralized her, they found drugs on her vehicle. Well, I tell you all of this because that's a reality. It's not a story. It's just what happened some days ago. Despite all of this, some days later, the prosecution office announced that the judge would continue her process free, which is not common in Mexico, but they said they didn't have enough elements to justify preventive jail. This is very different from the version of the judge that declared once she was freed that when she was arrested, she was subjected and subdued, and they forced her to fire the weapon, and they planted drugs before having her incommunicated for more than 5 hours and exercising psychological torture against her. This succession of events represents most of the problems that people in Mexico have to face when we face a trial. Then I'm going to explain this a little bit more in detail. The first element, The first element that's our concern is that those that go to a state court, they cannot ask for any explanations on the final resolution of the trial. But after being freed, the judge said that it was common that the president of the courthouse talked to judges. So when she called her to meet her, she threatened her, saying that if she didn't come, she would face some retaliation. In Mexico, the situation is very common. One of the obstacles that people face in order to have a fair trial is that judicial authorities can pressure judges to modify their resolutions, their sentences, their rulings. And another aspect that should be of concern and worrying is that in the first resolution, the judge did not take into account all of the evidence. Actually, in the interview that I mentioned, the judge recognized that there were some omissions when dictating her ruling, arguing that the audience had taken more than 15 hours and it was a very tiring situation. She didn't say it like that, but she meant that she could have been negligent, and you can understand that that she was tired. And because of being tired, you can explain that she was negligent. But we know that in Mexico, it's common for judges to act negligently. Now, for a study on the judicial career that we carried out in Mexico, Evalúa, some years ago, interviewed more than 200 judicial and lawyers, officials in the different states of the country, and most of them mentioned that one of the main problems for the proper functioning of justice application is people that have a jurisdictional position without having the right skills or capacities to perform. And this happens in every level, the judicial official all the way to the magistrate. And at the same time, it is due to the fact that many selection processes do not allow to ensure to designate the right persons for the position because of lack of credibility, transparency, and many times it depends on political family relationships than having someone that deserves to be in a position. The third element is the suspicion that the judge's behavior was the wrong one because the judge is corrupt. There we have another explanation on why it could be hard to have access to a fair trial in Mexico. Actually, there is a perception in Mexico that there is justice for people that have money and another type of justice for the rest of all mortals. And certainly there are many spaces for corruption in the judicial processes in Mexico, from the lowest levels all the way to the highest levels. And because of the time I have left, I cannot elaborate on all of these. However, we do know that it is a very common problem in Mexico. However, we have the fourth element. Lately, it has become a national sport, I would say, to accuse judges of being corrupt, particularly because they free criminals. And the governor of Veracruz only repeated the words that our president says every day during the morning session. And the problem with these accusations is that they violate the principle of presumed innocent. And for our politicians, if you free a criminal, then you are a criminal. They rarely say assumed or presumed criminal, and when these people are not held in custody or they are allowed to continue their trial free, then they are accused as corrupt judges. And other times it is considered that the judge is in charge of freeing these assumed criminals without taking into account the many deficiencies that investigations by the public prosecution offices show, and that many times judges do not have any other option but to free them. The fifth element, going back to our case, when the government said indirectly that the judge was the reason why this person was arrested, I find it quite concerning because this would be completely illegal. Judges cannot be destituted, nor they can be arrested because of their resolutions. If you consider that a resolution is not adequate, that you can appeal, which was the case, the concrete.
En dado caso, si existe la sospecha de que una persona juzgadora actúa de manera indebida, pues,
If there is a suspicion that a person is acting unduly, then those that have to investigate is the judicial power or judicial branch. And if there is a crime, then they should denounce it before the public prosecution office. So these situations are never heard of in Mexico. However, it concerns that the political branches accusations can reach this sphere. The sixth element, and I'm soon to conclude. The declarations of the governor show the true reason why the judge was arrested, the official reason, and because the governor never mentioned what actually happened. So what happened was that the judge did a traffic illegality, and then when she was arrested, she was forced to fire her weapon, and this is like out of movie, but something that we've seen many times, how the security forces in several situations have manufactured guilty people. This could happen to any person in the country, and this is quite horrible, and it has happened to many people. But it is very serious when this happens to a judge. Not that a judge is more valuable than the rest of the citizens. That's not what I mean. But what I mean is that when it happens to a judge, they do not only threat the person, but what they aim for is to influence on their resolutions. And it has to be clear that the message that was sent was not only directed to Angelica Sanchez, the judge, but to all of the judges around the country. And the message was that you can be stopped and planted evidence because of the resolution. So how can we expect for judges to take resolutions independently when they live in fear? I wonder. And the seventh element is not directly related to this shameful event, but with the context within it happened. It is important to remember that one of its main characters, the governor of Veracruz, organized on May 20th a demonstration against the Supreme Court. After this one, accepted many resolutions that went against the wishes of the party that's in power today. And during the demonstration that was celebrated by the president that congratulated the governor for organizing it, the manifestants brought coffins with the image of the president of the Supreme Court and another minister. That hate speech towards judges by the political branch is very dangerous because it could have irreparable consequences. Who can tell us that after this speech, someone is not going to want to kill a judge, won't have that urge, that impulse? And actually, this has already happened before. On December last year, a local judge was murdered in Zacatecas, and in 2020, a federal judge was murdered in Colima. And this brings us to another problem that we have in Mexico. Certainly, there are corrupt judges. However, there are many judges that are threatened. And, of course, the threats coming from organized crime or the political branch itself are another obstacle so we can have a fair trial. Having said all of this, I don't want to be negative. I feel that I am going to make you cry, but there are some things that we could do, I guess. But if it's okay with you, I would leave this for my second intervention. Thank you very much.
Muchas gracias, Laurence.
Thank you very much, Laurence. Well, certainly, these are the facts, and reality just represents what's going on. So we would have to see later on during the day what are the possible solutions to these problems. For now, I would like to pass the floor to Dr. Pedro Salazar. And once again, thank you so much for welcoming us here at your home. On the contrary, thank you so much for inviting me to share this panel with Laurence. I would like to thank the organizations, and among them this institute that I am proudly part of. Now, the reflection that I will share with you specifically addresses, as Laurence just mentioned, the topic at hand, systemic problems that hinder access to a fair trial in Mexico. And of course, I will focus part of my reflection to the criminal aspect, but I will also address other aspects where justice, unfortunately, tends to be absent. First, regulatory problems. I think it is important to start there. There is a complex legal design that's very hard to access in Mexico. Our constitution itself has turned into a very difficult reading type of document with a lot of standards and rules, very confusing one. It is a constitution that is 3 times longer than the original versions of 1917. And in some articles, it is even kind of, it has been excessively deformed. I won't elaborate, but let me just give you an example. For example, Article 41 of the Constitution, in 1917, it has 63 words. Now it has more than 4,000 words, and it is the article on the regulation which regulates every electoral matter. But it is important to highlight that we have a constitutional problem in terms of regulatory design, which is quite complicated, that makes it very hard to access constitutional standards for all of the citizens. Now, constitutionally speaking, I would like to also mention a problematic article, Article 19, that contemplates preventive custody by law in the Inter-American Commission, because they know the particularities of this very complex problem in Mexico. Actually, there is a ruling by the Inter-American Commission of some months ago that declares unconventional according to the 19th article, and it clearly establishes the need to be reformed. However, what we've seen is a silent omission by the Mexican state. Nor the government nor the legislative branch have been in charge of that mandate, that conventional mandate, translated into a firm ruling by the Inter-American Commission. And it is nothing minor, because preventive custody by law is something that countervenes international commitments, and it's a topic where they expanded the legal characteristics list, and this happened during this administration, and it also has a problem of legal taxativity in Mexico, because the wording of the criminal typification or the figures that cause preventive custody by law is quite open, from break and entry, fuel, burglary, and I mean, there's a series of figures, legal figures, that give legal uncertainties to citizens with a particularly serious and draconian law. And what's at stake here is people's freedom in Mexico. This regulatory complexity, constitutionally speaking, is also reflected at a level of secondary laws. If our legal design in the country has become quite complex and inaccessible, will only result in the variable, which is the federalism. Federalism makes something complex at a constitutional level even more complex. And we have included even a series of intermediate level laws, which of course complicates everything even more if we look at the codes and the laws of the 32 states. So knowing in which regulatory level we are standing on is quite complex, and it is quite complex for those of us that call ourselves legal experts. So imagine those that do not know about these complex topics. So this generates uncertainty and a feeling of impunity and a feeling of vulnerability, because those that face a trial in this country are very uncertain of what could happen to them from the point of view of the regulatory standpoint. In that regulatory standpoint, that's constitutional, federal, we have to add the complexity to have access to jurisprudence due to the national courthouses, the federal judicial branch, but especially to the federal law courthouse. And then you have another problem in order to anticipatedly know what is the framework, in this case, the jurisprudence framework that will prevail when justice is aimed to access. So in this idea, I think that the regulatory field is the one that has to be considered because there is a last variable here. There is a huge trend to change the regulatory framework. So anyone in Mexico saying that they're an expert in work-related matters or in civil or family-related matters, I think that they're lying, They're lying because the regulatory framework just changed. It is ever changing. And we never know with certainty how it is going to function, especially in jurisdictional venues. Today, courthouses should be courthouses in labor matters. So I think that there is a legal uncertainty for those that need to have access to any trial in that matter. And also civil and family matters also changed in their code, which promises to be a good idea, but that ended up changing the rules in a very relevant way at a national level because it is actually a code that's very difficult in that nature. And I steer clear from the regulatory ones. Now let's talk about institutional design problems. When we talk about impunity in Mexico, we all know the numbers. We always talk about above 95% of impunity. I'm thinking about criminal levels. So we tend to react, as we've seen, and Laurence already discussed it very well, we tend to react in a hostile manner with judicial matters as something ethereal and amorphous when we talk about the Supreme Court of Justice specifically. But what we should consider is the local justice. That's what we should be concerning because that's where the hardest problems lie. And Laurence just gave us a very clear example of justice application in the state federation because there is a huge lack of possibility to apply justice. And I'm thinking about courthouses in this first reflection that I share with you. So in this sense, federalism has been quite dysfunctional in terms of fair justice, strictly speaking. Let me put it that way. And it is a problem that we have to address because as it normally exists, there is a disparity in the different states within the country. So the geographical location where you are at could determine what's going to be the quality of justice that you will have access to. And I think that this is very serious and we have to highlight it because it is a problem of institutional design, but its consequences, as I mentioned before, is a deep vulnerability by people that need to face a local trial. This deficit that I am focusing on in this first reflection shared with you towards the judicial branches, in plural, exponentially increases if we think about the prosecution offices. I mean, once again, it's very easy to accuse the judicial branches of lacking in responsibility on the criminal percentages. But the most serious problem is on the other side. In this country, there are no investigative police departments. They are just not there. The prosecution offices do not do the work that they should be doing. And there is and Santiago knows about it. And I'm so glad to see you, Santiago. There is no institutional capacity. There are no professionals throughout the states, nor at the federation level. There is a very important deficit in terms of police officers, and that deficit, that lacking, of course, has a consequence in the huge impunity percentage, but also in the arbitrary events and in the excessive use of coaction, as Florence just mentioned, in a specific case, very fluently, because it specifically targets a judge. But this type of arbitraries, this type of abuses are explained greatly because of the lackings of institutional capacities to procure justice, not to apply it even. Now, the next element that I would like to discuss at this level of institutional design, and I am just talking about a mapping here, but the idea is that we were asked to look at systemic problems. Well, one of the systemic problems is that our national systems haven't worked out, haven't functioned properly. We've tried to implement, for example, let me give you just 3 examples. A national anti-corruption system that hasn't been able to function as system nor as a regulatory project at a national level. It doesn't work. The anti-corruption national effort is not working, nor the fiscalization one. This has to be brought to a third system, which is what brought us here today. The national system of public security is not working either. In this country, during previous decades, we tried to design constitutionally and institutionally national systems also in terms of transparency. The best one is still the electoral ones, but for different systems, national systems that due to its design, due to the authorities not being interested, and many times because of some authorities in charge of making them work not being interested, they are just not working. And one of them is the National Institute of Public Security. All of these that I just said of institutional lackings, not really regulatory lackings, helps us understand why what the government has been following during this government has been the application of the army, just militarizing the country. So this is why the prosecution of phenomena such as corruption and public security matters. Well, what we've been doing in that world is just going towards growing, and for a long time, an irreversible militarization on the matters of public security that shouldn't be done by the armed forces. We've said it with constitutional arguments, but also with institutional arguments, but it's there, it exists, and that trend is very hard to revert it because of an institutional projection issue. Corporations that acquire resources acquire power and they acquire presence, and when so, they are hardly going to renounce to them. So in this sense, the armed forces have become a very powerful corporation in this country that has a huge capacity to condition the decisions of civil authorities. And it is very hard to imagine how this reversion that has been promised could ever happen. And far from eliminating it, militarization has increased. So it has to do with a structural lacking in the institutional design of the authorities that are conceived to be able to face the phenomena that I've referred to institutionally speaking. And last but not least, in the institutional field, a great attempt just failed. The daily justice package during the previous administration was a set of institutions that were designed at the constitutional level that, among other things, and I'm going to simplify this a lot, that aim to bring justice to people, bring it closer to people. This meant bringing justice to communities, finding controversy resolution mechanisms via intermediation, and to make it an instrument that was close to the community, but it has failed tremendously. This is another constitutional, institutional design that is there, but that doesn't have any practical effects in the reality of daily living in Mexico. And this would be, let's say, systemic problems that prevent us from having access to a fair trial. And last but not least, other 2 problems, but these problems are strictly political type of problems. I do believe that Laurence has already gave us a comment. Federalism once again reappears as a problem, not only at a level of constitutional design, legal design, institutional design, but also as a political problem where the arbitrarity with which some federal governments act is absolute and with a huge impunity. The example that Laurence brought is the one that I had here in my notes, which is a very recent case, the case of Veracruz state, where abuses within the state have happened for decades. They are not specific of this administration. It is a state with huge levels of impunity, but also of state violence against people. Criminal violence, and one that has been arbitrarily faced with a huge number of human rights violation, and that today it just leaped in attacking the ministries of the Supreme Court of Justice directly by the governor of the state, and the example that Laurence just gave us, which is a very fluent, clear example that's of great concern of abuse and violation of the rights of a woman judge for exercising her profession, for doing her job, for applying justice. And I think that this is something that we have to consider. Federalism is also a political problem, a very serious one. And the second one is the confrontation that those of us here in Mexico, we know it.
We're here, and those who are abroad don't have that clearly outlined, but there's constant, permanent, frontal participations or announcements of the executive branch. The president, before the judiciary specifically, he's made some announcements versus the Supreme Court of Justice. You know, you can look for this with Erdogan. You can see other cases or analog scenarios, but the pattern here is the same. There's stigma of the triers of fact or justices. They disqualify their hard work. They stigmatize also some specific actions of corruption in the justice system. There's a permanent threat to their work stability and to their economic stability. And on the other hand, there is a frontal, and I think it's very harmful. It generates grievances to point fingers at certain individuals who are triers of fact when they issue rulings that do not please the government or the former administration. And I insist, these are situations that are sourced from the executive branch or the president of the republic, which is extremely it threatens, because he disqualifies the judiciary or the apparatus of justice, the citizens or the Supreme Court, and towards the Supreme Court chair. In the last few months, what the president of the republic and the president of the court have done is totally unacceptable, and that has generated a context of hostility, pressure, and a process of disqualification that difficults the role of the Supreme Court of Justice in its mandate. Each time the court rules in a decision-making process, because it's constituted to rule and to the issuance of sentences. I mean, there's a majority of analysis, there's precedent, there's the rhetoric that's populist in its nature, and there's public announcements from the president that worries us all. And if we think about it specifically about the process of having justice administrated, today, the president of the republic, just a few minutes ago, just said, and in his announcement, he said that he tried to participate or intervene, and he directly acknowledges that he tried to intervene in the ruling of the Supreme Court of Justice that was simply unconstitutional. And let me, you know, the National Guard is an entity that's militarizing, and the court ruled against the participation of the National Guard because the police, as it's in our charter in Article 21st, and the announcement of the president today was, and I quote, they used a resource to declare that my process was not constitutional, and I decided to, put my hands into it. I spoke to 5 justices of the court, and with 5, and I proposed these to be appointed, and I talked to them to guarantee that there's 4 votes. However, 2 of these justices failed on me. And what underlies, and I quote, it's like they had already been doing things wrong. These justices had proven that they had done things wrong. So it's necessary for me to talk to them about this, so to show them how important it is. I spoke with 5, but with 2, I couldn't communicate. That's today's deposition or declaration of the president of this country. It generates a terrible, enormous grievance to the nation. It's a situation that has to be analyzed by us on the specific grounds of the specific subject that's our calling today in this venue. I mean, we've been called here to discuss these issues, and there is another institutional, political, regulatory framework level that's object of our analysis. And you know what leads us to issue decisions through our structure or system? You know, we have to analyze the cultural, social issues that affect this country, and those problems have an impact on the process of having access to a fair trial, because there's injustice in our whole structure. In the citizenship, there's a lack of fairness, there's a lack of equality, there's a lot of violence, there's discrimination, amongst other elements that, you know, there's many to discriminate due to gender issues. Now, in the environmental agenda, also, we can speak about what's happening socially and the problems that are embedded that affect the nation, even culturally, that translate into structural lack of justice in the Mexican state. So it seems to me as if all of these elements were object of our identification. I hope that I've been clear. But systemically speaking, we need to work to guarantee and protect our rights to a fair trial in this country. Thank you all very much. I hope you're all having a great day. Thank you very much, Mr. Salazar, Dr. Salazar, for giving us such a broad explanation of the systemic problems with your stance or your perspective. And thank you for sharing this today. Without doubt, I think that today we need, in this economy, in this nation, a strong, solid institutions. Unfortunately, though, there's elements that threaten that. There's entities that try to affect the system, you know, from the state and the branches of government and powers. But I believe that in Mexico, we've been living the situation for many, many years. We think that sometimes problems will just find a solution, and the solutions are the drafting of new laws and wording the right law, and then we forget about how to implement that law. You know, it's a federalist nation, and there's budget issues, and budgeting this nation leads us to analyze the National Criminal Court reform there, the amendments, and we analyze it. It's not easy to implement. And if there's no budget for that implementation, then the solutions are not close. So that's one of the issues that was, thank you for your comment. Your comment was great. I don't know if you have questions from from the public, or I don't know if you have questions for us. Any stakeholder that has comments, questions for us, please use the microphone. Thank you so much. Good morning. I'm Fabio. We can't hear him at the booth. No lo escuchamos en la cabina. Okay, yes, we do need the microphone for everyone that's connected. Thank you so much. Good morning. My name is Pablo. I work in an association that's called Tabla Termix in Catalonia. I'd like to ask you, how can civil society as a stakeholder work, contribute with solidarity? How can we contribute or help from other locations, from other countries, from other places? How can we help? How can we contribute to narrow those systemic gaps? What can we do from abroad? Who wants to answer? I was going to say, you know, I'm also from an entity that's constituted from civil society. I'm proud to be so. Now, just that, you know, your question, Pablo, is a great question. Like, it's because on our day-to-day, I think that right now we're going through a complex time in Mexico, because on one hand, what I expressed was saddening, and there's structural issues and problems that we're facing, but in this time, civil society plays a crucial role. We have to fight, we have to defend our institutions. Pardon. And I'm just, it just, I have these feelings, I have these emotions. They're just, okay. Pardon. We have to acknowledge that there's been, our institutions have been built. They have to be object of our defense. We have to find ways to build that strong defense in our institutions. And what we have to do is use our institutions correctly. But Pablo, specifically trying to answer your question, what can you do from abroad? And this is an event that's of global nature in its spirit. I think we have to be very objective. We have to communicate this to our societies and warn our society about what's happening, because I have the impression that if we communicate with other entities abroad, they might think that things are better than they actually are in our institutions. And speaking specifically about the process of administration and fair trial in our country. And if I say solid words, what I'm saying is very serious, it's very delicate. And what's happening with the executive branch or the president of the republic is very complex, and it affects the process of administration of justice. It has no president. We had faced times in history where there's been confrontation between the executive Calderon and the president of the Supreme Court, Juan Silva Mesa, that had to do with a justice reform in the criminal court and the criminal codes in 2008. They called it like the fast tracking and release of frivolous laws and of those who are triers of fact. And in Mexico, we hadn't lived historically this level of confrontation between the institutions that guarantee and are the counterweight in general. But speaking specifically, there had not been a confrontation with the judicial branch in the country. It's without precedent in Mexico. We have to communicate this with our citizenship based on experience. And I'll tell you, is extremely important. I insist on that point. What's been expressed by the president of the republic about the chairwoman of the Supreme Court of Justice of this nation is not acceptable. There's hostile activities. There's been points accusing people constantly because the triers of fact and justice, or chief justice, is doing their job. That's what we're seeing. They're working under firm, solid grounds with a legal protection in their jurisdictions, and communicating this to society is necessary. And I'll conclude. Laurence, don't let me lie, because I know the floor's yours now. The word's for you, ma'am. But civil society that's organized has also been object of hostile activity in this country. Thoroughly, profoundly object of hostility. Our citizenship is not protected through government at a national scale and at local federal entities scale. And I must say this because civil society has its way of organizing itself, but today it's fighting and swimming against current. That's why Santiago just mentioned that. He just got to our venue, as well as Laurence. We're talking about touchy issues that have to do with situations of cases in which there's people that have disappeared, cases that have been filed, but communicating this to society as part of our responsibility is extremely important. Pardon me. I was just going to say more or less the same, but, in effect, what I'm going to say, I'm going to repeat it. It's fundamental. We're here to defend. The judiciary branch is here to defend. The system's not perfect, and that makes it difficult at times. And you're not going to allow me to lie. When you start defending, and they're questioning us, and why are you defending these entities if they're so corrupt? There's some triers of fact who are corrupt, but it's not majority. It's very complicated. We're highly critical. We think about how things are being done here. But whichever way, we're here to defend them. And I also want to mention, it's not only us from civil society and our entities. We have to do this from the institutions that administrate justice. I've observed change, but that change has to happen when we open up to being accountable, transparent before our societies and citizenship. If you want our support, we need the institutions to partake in that change. Those institutions have to also be part of that change. I've observed this at a local level. Specifically, some of the local levels of the judiciary are just mere observatories. You're speaking about the administration of justice on a day-to-day basis in the state of Mexico. There's caravans that fight for justice, to make justice be part of rural communities. There's efforts, there's programs, there's initiatives, there's good things, but we have to do more. Why? Because it's important. It's important for the judiciary branch in its levels to understand that right now it's breaking point. So I believe and I feel that it's today we're defining, outlining the scope of what's happening with our system and institutions without doubt. Without doubt. We cannot just think it's not just a luxury. We cannot let the judiciary branch debilitate. A state that's sterile and object of erosion, then this is fertile ground. We have to build that fertile ground, to build that rule of law. We have to maintain this state and our grounds healthy as much as we can, preserve what works and correct what's not functional. We have time for one last question over here. We have a pause for a break. Thank you so much. I'm Raul Arroyo. My question is for Pedro Salazar, doctor. Now, doctor, I'm trying to be very precise. You spoke about the fact that the federalism is clearly dysfunctional. Specifically, you've mentioned in the drafting of the laws or provisions here. What's your perspective? What are the grounds? If you think about the feasible, possible solutions here, if we're going to keep this federal model, this federalistic model here in this country, what are we going to do? If we're going along these lines, in which we have drafted our national laws or standards here, or is it the corpus juris or the body of law that's autonomous to each state entity, or is it federal, or I'm just talking about the generation of our laws here. So I'm not an expert in the federalism. I like Jose Maria Serna de la Garza to answer your question, but thank you, Raul. You know him very well. You know this very well. You know the phenomenon fairly well. I mean, from the stance of public function, of public administration in a state entity, you know that the problem is in its structure, and it's serious. In effect, there's a dilemma that's just tacit, expressed. Now, if we nationalize more, we can strengthen the institutional capacity at a local level. I think I'm more towards the second alternative. The fact is the local authorities are closer to the citizenship or the state entities. We have to strengthen the local authorities and strengthen the institutions in the state entities, as Fernando said. That requires budget allocation, human budget allocation, technical allocation, and budget. We need to strengthen the institutions' capacity to submit resolutions on site, in situ. That's a great challenge there. Why? Because the rest would simply apart the institutions from the citizenship. The facts here of what Laurence is saying, the surveys confirm what's said. There's echo. I mean, justice is being disqualified, and it escalates to the Supreme Court of Justice of this nation. That's a clear, tough indicator. We're not putting our eyes in the gaps of the administration of the local levels of justice administration that aches and pains our people more. And we should bet on what's happening at a local level that requires national planning and commitment and engagement from the state authorities. And I believe that's our heading. I believe that we have to stress on those points and insist, because if we strengthen the local, then there's major responsibility at that level, because we have other potential skills to properly administrate justice. Thank you so much. Well, I only have to mention that Dr. Jose Luis Caballero had to, well, he apologized. He had to leave. He had a last-minute emergency. It's a personal emergency, but we know that he would have loved to participate in this panel discussing this subject. He's going to send us a note or a message, an announcement. Thank you so much, Laurence. Thank you so much, Pedro, for your generous and brilliant participation. So we invite you all to enjoy a break, a pause, 20 minutes. 20-minute break. So please come back. Resume. Come back to this meeting room at 12:20. Thank you so much. President of the European Association of the Jurists for Democracy and Human Rights of the World. And I'm part also of the committee, the steering committee that has organized this. Now we're going to talk about the human rights and the integration of these to due trial or fair trial in Mexico. We're going to be discussing this in this expert panel. We have been fighting for this respect personally. We've been fighting to have access to justice, for the survivors of grave violations of human rights to have access to justice. Now, before I present the rest of the panel and open the floor, allow me to tell you that I'm honored. I'm honored to be here with you. And if today I've become an attorney, barrister, activist that fights for human rights of women and for human rights, I've become this because of the great example of a Mexican friend of mine, Luz Estela Castro, great attorney, Lucha Castro, great defendant back in 2015. When I was still a student at my university, she came to Italy to talk to us about the fight against impunity, the fight against the feminicides that's taken place in Chihuahua. Lucha Castro is one of our jurists in Ebru Timtik award. She's been an inspiration for me. And thanks to Lucha and Marcela Lagarde, and thanks to the fight and struggle of all Mexican activists who have been present in Italy and in the world speaking about feminicide, as a result of the institution's responsibilities, we've obtained results before the Inter-American Court. So there's justice for Mexican activists, and the cases have inspired many stakeholders globally. There cannot be a fair trial, if we cannot guarantee fair access to justice, because there's people that are suffering the perpetration of violations to their human rights. I collectively thank you all for lawyers, activists. I thank you all, stakeholders, and everyone present here in this venue in Mexico. Thank you for fighting. Thank you for giving us results. Your results have generated an impact at a global and national level. You have inspired others to continue battling in the legal realm of things. The panel members are Roberto Lopez Miguel, attorney. He obtained his degree or license in 2006. He represents the collective Los Otros Abogados. He's also fighting for those who have been politically detained amidst the social repression actions from the Mexican state. So as the case of the political people that were detained in Texcoco and San Salvador Atenco in the state of Mexico. And he's also fighting for the Mexican students that disappeared since 2015. He's been part of the collective entity called Los Otros Abogados, or the other attorneys that are the defendants of a person or citizen that's politically persecuted, Peralta, who is from the Mazateco community of Flores Magón, Oaxaca, who has been condemned or accused to 50 years of prison because he was defending the autonomy and autodetermination of his community or indigenous populations. He opposed the political economical interests of a political party called Morena and a family that's present in power in Oaxaca. He's also the attorney of the indigenous member called Aldama Perez, who has been detained since 2006 in the precinct of Sonora. He received a sentence of serving many years in prison for defending his territory, 14 years in prison, and he was also opposing the construction of the oil ducts in Sonora from Sempra Energy Company. Now, we have our attorney, Victorico Galvez Perez. He is an attorney that works in Fray Bartolomé de las Casas Human Rights Center, located in the state entity of Chiapas. They document or have a case file and enter into litigation at an international and national level where there's violations to human rights of people that have been detained, tortured, and object of disappearance, arbitrary detentions, forced displacement, and full total repression against people who are activists that fight for human rights, journalists, and also communicologists. They're here to defend these people from different areas and indigenous populations. He's also working for the entity called REDD. Ms. Valentina Rosendo Cantu. She's a part of the indigenous populations from a community called MEPFA in the state entity of Guerrero. Valentina Rosendo was a victim of sexual violence and torture through the military or due to military personnel in 2002 when she was only 17 years old and could not speak Spanish. Since then, Valentina has been a fighter in different levels at international level. She has escalated this to repair the damage. She has been supported by different civil organization entities who support her. Her case is a case of reference against torture, sexual torture, and the militarization. Back in 2010, the Inter-American Court of Human Rights submitted or issued a ruling against Mexico. As Mexico is responsible for terrible violations against Ms. Valentina. These violations were committed under a context of poverty with the military involved. Back in 2018, her case that was filed was the first in its case, which was object of trial in the civil court after the Inter-American Court issued its ruling. That's a case of reference to obtain justice and similar or analog precedent. Now, we're still observing complying with the sentence or the ruling that was issued by the Inter-American Court. Marta Figueroa Mier is an attorney. She's also a defendant of women's rights. She's an activist. She has a lot of experience. She has been defending and communicating human rights to people. She's the founder of an entity called Free Women called Column, and a group of women of San Cristobal de las Casas. This association was constituted in Chiapas and awarded and recognized by international global institutions. But at a personal level, Ms. Marta has received an acknowledgement. The acknowledgement has been expressed by the families of the victims who acknowledge her hard work. She's a feminist and a professor as well. And now the floor is for, as I've said, Mr. Roberto Lopez Miguel. Thank you so much. And first of all, I'd like to thank you. I'd like to thank the hosts for namely and inviting me to this forum. Thank you for considering us to be part of this expert panel. I'd like to thank the Research Center of UNAM. Thank you for opening the doors of this venue, of our home. It's always an honor and a pleasure to come back to the university that led us to obtain our degree. I thank my panel members, as I've said, and thank you for giving me the opportunity to listen to your kind words at some point. If you ask me, what is a precinct? What is the jail system? My answer is the trash, the landfill of a socioeconomic project that's generated to throw in all the people or subjects that are bothering someone in society. So a precinct is usually populated by the poor, and much has been said about human rights. Currently in our country, there's people, civil association, commissions that have been constituted, which are expert panels of human rights. Universities and public and private systems have had in their syllabus and credits, degrees, accreditations, and postgrad studies in this field to be avant-garde, so all the studious elements can contribute at some point. How do we analyze human rights as the defendant or the person that's being accused without, if you don't have access to a fair trial and the respect of your basic human rights? I can explain with a dissertation the problem. On the contrary, I'll use cases of reference or experiences as reference to explain what we've done as defendants of victims who have been detained, processed, and object of rulings or sentence due to political issues in irregular trials that are not fair. People have been detained because they defend water, education, their territory, natural resources, their autonomy, and self-determination capacities of the people. They're opposing transnational company initiatives, government and state projects, like the network of pipelines in Sonora with that energy company, the Mayan train, the corridor, or the Istmo train or belt of Tehuantepec, just to mention a few cases. What is due process or a fair trial? And who has the right to access a fair trial? Those questions can be posed constantly amongst people, family members, and collective entities. So NGOs and other entities that are fighting to defend the rights of political people who have been detained. As I explained in the previous paragraph, anyone who has been object of detention because of their political ideas amidst a context of repression through the Mexican state or authorities is considered a person or a subject that's persecuted due to political reasons. The due process of fair trial, Section A, is access to justice in a formal way through the system of justice administration. We should reach resolutions for those who are accused and object of a defense. We have to solve controversial matters or causes so the ruling really corrects and is aligned with the rule of law, making sure that the ruling is fair. Now, the access to a fair trial has specific characteristics. The hearing has to be public without delay before a tribunal that's unbiased and independent with a proper defendant before the accused, whether it's a private defendant or public accused. The person is under the principle of presumption of innocence. And there's a principle of simply not accepting blame when there's no blame. All the legal guarantees and the principles amidst a fair trial are guarantees. When there's social defendants that are here fighting for communities and for people's human rights. I mean to say, when we're before a criminal cause that have been fabricated by the prosecutor, which are taken to trial, verifying each violation amidst the process, all the steps or proceedings that lead us to issue the condemnation of a person. So then we question the independence of the administration of justice. We think about the penalty or sanction that was imposed to a high school student of UNAM back in 2016. He was imposed in its sentence 33 years to serve in prison and 8 million's worth of payment. That kid was considered that he had committed a crime. He had attacked public police and its criminal type, amongst other types. Now, after they exhausted all the resources, they went to appeal and direct injunction or protection. The criminal case led us to a reduction to 4 years, 7 months of prison. So he had to be in jail, detained, so he could at some point recover his freedom. There's a case file in analogy. There was a criminal cause committed against Perara Betanzos from the community of Flores Magón, Oaxaca. He was detained in 2015, being accused by the prosecution, sentenced and accused in 2018, and served 50 years in jail for the crimes of homicide and other types of crimes. However, we exhausted the resources, went to appeal, and in 2019, there was the issuance of an order to restart the procedure until the final phase of the court case. And he was completely acquitted at some point because they couldn't determine the criminal participation due to the crimes he was sentenced for in the first instance. However, 13 years after his release on March 4th, 2022, the freedom from the criminal court was then modified. He was detained once again, and he was imposed a sanction to serve 50 years in jail when he was considered completely responsible, liable for the causes or crimes that he was processed for and sentenced. We're still waiting for a direct injunction or amparo proceeding that could give that person back his freedom unjustly taken away. There's another criminal case that was imposed against the Yaqui indigenous member called Anyaki Perez back in 2016 in Sonora. This subject was processed, condemned in 2018 to serve 15 years in jail, of 15 years, due to a simple simple with intent, or homicide committed with intent. In the first instance, we reduced the penalty in 2002 and complied to the direct injunction or amparo ruling. The common denominators are of the previous cases filed I mentioned is that social unrest is criminalized and justice is poorly administrated. Having a criminal cause is a cause to control the society and to try to administrate justice, imposing while sentences that serve as an example to avoid people from going to protests and that do have an impact and transcend in our society, specifically in Mexico. The general landscape in the field of human rights, respect, and access to a fair trial. For years, there's a lack of credibility towards the system or institutions that administrate justice.
Facing the cases of violation of human rights where the authorities have failed the victims, which has motivated to seek for justice at an international level and turning to the Inter-American Court of Human Rights for help that has issued several rulings against the Mexican state, finding it responsible of serious violations of human rights. Along to this, particularly in the government headed by Mr. Andrés Manuel López Obrador, the president, we have concernedly looked at the relationship between the executive branch and the judicial branch, doubting the separation of branches and the judicial independence, and the existence of contempt to judicial resolutions is seen. We have seen the mediatic lynching that happens every day during the morning sessions to journalists, human rights defenders, and social fighters because they think differently, and for questioning and going against the political economical projects of the current government. Today, this idea, if you're not with me, you're against me, is empowered once again. So that's why we're criminalized and murdered, as it happened to the apostle of the Morelos mega project that was executed in 2019. We see with huge concern the extrajudicial executions that the military carries out against those considered to be enemies, simulating confrontations that do not exist and altering the place of the place where everything was carried out. They deserve to be executed without guaranteeing them the right of a fair trial. So it's the enemy, and you have to eliminate it. That's the and the exception right is applied. So the summary will impose the presence of the army on the streets, creating public security activities and they are not trained for that. Regardless, during the campaign, it was promised that they were going to be sent back to their quarters. Definitely, the continuity of the Proyecto Integral Morelos and the oil, the gas duct Sonora, as well as the Mayan train and the interoceanic energy have been considered, and it will bring as a consequence the stripping of land and finishing the natural resources. And the affected communities are also starting files of investigation, and they are looking for some judge that will be brave enough to punish the true enemies of the community. It has not been easy to walk this path. We have faced a lot of difficulties and legal irregularities that in a true state of law shouldn't be allowed. But above all, we have faced the political, legal, and economic power of the state, fighting unequal battles where the state is judge and party, and they use whatever they have at hand to criminalize and exemplary punish those who oppose the capitalist regime. However, we won't desist from our goal. Today, more than ever, we are convinced that we can make the difference and that our effort will be added and multiplied by others, with others that have been walking this path for longer, looking for a justice ideal, so that for those that have been denied of it. And if joining our efforts, they will break down the wall of injustice that for a long time has been built by those that rule our country. Last but not least, the society and social organizations could promote a change, and we can demand a total cleansing in the justice application world, so that other generations can be in charge of that important function by the state, because it is not enough to have a simple training on the new criminal justice system, making us believe that everything has changed. We need more than that. It will take, however, we will continue to insist and fight tirelessly until we manage it. Thank you very much for your attention. Chiapas is not a quarter. It was the army. Chiapas is not a quarter. It was the army. Freedom to political freedom to political imprisoned people. Solidarity. I would like to thank Mr. Roberto Lopez Miguel, attorney, and Solidaridad, because applying the criminal law is unfortunately an international trend that pollutes the judicial system in many countries. And Ebru Timtik is also a victim of that same crime. Thank you very much. I would like to pass the floor to Mr. Victorico Galvez Perez, attorney. Good afternoon, everyone. First of all, I would like to thank the organizing committee of the International Day or the Fair Trial. And I would like to, and it's very unfortunate that they've chosen Mexico because of all of the human rights violations. It's very sad. Thank you so much for hosting this event. I am Victorico Galvez Perez. I am a lawyer at the Fray Bartolomé de las Casas Human Rights Center at Chiapas, at the Mexican Southeast, where hope begins. Fray Bartolomé de las Casas has 24 years of experience in promoting human rights and defending human rights of indigenous peoples. Before discussing the matter at hand about fair trial and due process, we would like to detail the serious situation of violence that the state of Chiapas is experiencing. For the last 20 days at least, there has been at least 3,500 people that have been forcibly displaced due to the dispute for the same territory by two organized crime groups. Simultaneously, there was a murder of 7 people and 3 more people in Alto Tzotzil region. And this added to the multiple attacks and assaults to communities that exercise autonomy and free determination as indigenous peoples, particularly what happened on May 5th. Having said this, some days ago, on May 9th, at the Fray Bartolomé de las Casas Human Rights Center, we were presenting our annual report that's called Chiapas is a Disaster Between Organized Crime and the Complicity of the State. We were presenting this on May 9th, and in less than a month, violence just overflowed. So I wanted to take full advantage of this opportunity to share that information. Particularly speaking, Chapter 5 of the report talks about due process and a fair trial. So that's why I wanted to share this information with you. So the chapter is called Creating Punitivism and Torture as a Systematic Practice. As we all know, in Chiapas, the accusatory criminal system was started in June 2016. So 6 years after this system was created, we have documented and evidence a pattern of guilty people being manufactured. When people are subjected to criminal processes, most of them under the preventive custody model. This pattern of manufacturing guilty people, we believe that it is fed by 2 situations. That the change of this adversarial system didn't mean strengthening scientific investigation capacities by prosecution offices. This added to the fact that the main population affected by this pattern is the one that has been systematically affected: originary peoples, indigenous peoples, people with scarce resources, as well as migrants. So instead of strengthening scientific investigation capacities, a pattern starts, which brings prosecution offices to mask their technical deficiencies. So manufacturing guilty people seriously affects the free development of a person, but not only the person that has been deprived from their freedom, but also their family members and the communities, breaking the community's social fabric of indigenous peoples. And this pattern has been fine-tuned, or we've identified that it has been fine-tuned, particularly by two matters. We're talking about Chiapas here. During the previous presentation, there was a national presentation. However, at a state level, the criminal system in Chiapas is quite deficient, quite lacking. So what we've found are poor practices. So the previous system compared to the current systems, the public prosecution offices did not change. The public prosecution offices have those poor practices and they just were carried over. Secondly, they appointed judicial police officers. They were appointed as investigational officers, so there was no training to provide a proper investigation or due diligence, or well, it was said only in words, but many times it has been evidenced that investigational police officers that used to be judicial officers have seriously violated human rights. So I'm going to go a little bit faster because of the time that I have left. So we have identified 11 steps pattern. It starts with the arbitrary arrest. People belonging to indigenous peoples are arrested due to an administrative felony or a minor felony. At the IPH report, the police officer informs that it was arrested because of a misdemeanor or that they were also found during the act. And in the public prosecution office, during the 48 hours that they have the right to keep the person arrested, they plant evidence. They create an investigation file, an alternative one, where they just manufacture evidence. And this evidence that's manufactured helps them get arrest orders from a control judge. And this is the third element, the request for arrest orders. And we have found there's a collusion between the public prosecution and the state attorney's office in order to get these arrest orders, these warrants, because they violate the National Code number 143, because a warrant has to be done in two ways. One is during a hearing or during the informatic system. And they just have these 48 hours to get that warrant. In a particular case that we are litigating, the warrant was issued by the control judge before the prosecution office requested it. I mean, imagine the level of that. The fourth step is the release. The person that was arrested is released. First, because of the crime, because it was a misdemeanor, or it was because they were found carrying some drugs, but there's never a release, a proper release by the police department. But once they are supposedly released, they are immediately arrested again. And the warrant is immediately executed for the second crime. And the second crime, supposedly, it is within the list of preventive custody. So let's go to the fifth step, which is the initial hearing. The initial hearing is because of the second crime, because the first one, they've already been acquitted for that one, for the misdemeanor. So this prevents the proper defense because the second crime is being debated and not the first one anymore. So they do not debate the legality of the arrest anymore. So there is a sudden transportation. They do not let the family members know. The public defenders tend to have a passive attitude during the hearing, and they do not properly advise the defendant. And of course, step 6 is being imposed or they are being processed. The process starts. they are taken to trial, but everything has been tainted from the beginning, from the moment the information was arrived, because the warrant was issued before the prosecutor's office even asked for it. So there's nothing to debate anymore. So the seventh step is the preventive custody situation. Here we've seen that the manufacturing of investigation files of the case have some serious aggravations to it. So there won't be any alternative precautionary measures. So the eighth step is being imprisoned for a fast trial. Here we have documented that 90% of the cases approximately, the defendant is invited to accept the fast trial because they offered a reduction of the sentence or the possible the possibility of parole, because the investigation by the public prosecution office is deficient, so they won't submit the evidence in the oral trial. And they know that. So the ninth step that we have documented is the time the preventive custody lasts. It's a prolonged term. It seems to be an agreement between the Supreme Court and the public prosecution office, because a lot of time goes by. It should be only 2 years, but then they end up violating this term, which should be 2 years and not more. The 10th step is given during the intermediate hearing, and this is towards the control judge. They do not apply the exclusion of evidence that have been obtained under the violation of human rights. When this is argued in Chiapas, that does not exist at all. So the criteria that have been issued from the Supreme Court do not apply there. So that's just written, but never exercised. And then we have the ruling, the 11th step. The ruling is issued despite having evidence inconsistency, forced testimony, and that there is not a proper investigation by the prosecution office, and the evidence burden is reverted to the defense, where it should be by the public prosecution office. And last but not least, the recourse of appeal. In the recourse of appeal, we have noted that 100% or 99% of the appeals are confirmed once again. So it does not work. And we should have to wait the direct injunction to have a favorable sentence, a favorable ruling at the end of the day, or the writ of amparo. So the affected population tend to be rural workers, drivers, people related to low income jobs and with a low level of education, primary, secondary school, or even preschool. Added to what I previously explained, and to conclude, in 2021, the Workroom on Arbitrary Arrests by the Human Nations issued opinion 243 and 221 because of the case of Marcelino Ruiz, where she expressed that in certain situations, the generalized or systematic imprisonment or other serious freedom violation, according to international law, could constitute crimes against humanity. The fifth case that the 5 cases that I mentioned that we have accompanied at the Fray Bartolomé de las Casas human rights impersonates the creation of guilty people, the manufacturing of guilty people, because it targets indigenous peoples. So we consider at this center that it is a state policy that just manufactures guilty people that would merit a special investigation as crimes against humankind, because it has systematically resulted in arbitrary arrests against specific communities. And the 2021 poll can attest to this. This states that according to the employment and the educational level, that's the person that's going to be arrested. And with this, I conclude. Torture. We consider that it is still quite rooted in the investigation police department, in the prosecutors and attorneys. One of the main actions is eliminating the possibility of survivors to have the fair trial. They are authoritarian, and those that suffer from this authoritarianism just end up in a situation of shock. And with this, I conclude. We documented this in one specific case. There was Carlos Antonio, well, I can't say his name, he was tortured and he was sent to the hospital. And for the initial hearing, he has to be brought in a wheelchair because of the surgery that he has to be subjected to as a result of torture. So he couldn't say anything at the hearing because he didn't know what was going on because he was at the hospital all this time. So, and with this, I conclude. On May 15th, Carlos Antonio and her partner that was also affected by torture, we had filed a suit against the government because of this systematic pattern of serious human rights violations. We have filed a complaint before the Human Rights National Commission because of the serious systematic violations that are very rooted in Chiapas courthouses and prosecution offices. And it also has repercussions in the National Code of Procedures. Thank you very much for your attention. Thank you very much, lawyer Victorico Galvez Perez. Thank you so much for your intervention and for the very concerning statements on justice in Chiapas. Now we are going to talk about the human rights defender, Valentina Rosendo Cantú. Good afternoon, everyone. Well, truth be told, to me it is a pleasure and an honor to be with you today. Thank you so much for inviting me. I would like to thank everyone, the honorable colleagues. Thank you so much for covering the expenses of my trip because I come from very far away in Guerrero. So it is very important to me to mention that it is a pleasure to see judges once again, judges that I met like 12 years ago. And my fellow friends from the different organizations, I'm so glad to see you again. Marta, for example, I'm so glad to see you again. So I am very satisfied with a lot of, I live with a lot of expressions of care. I am not a lawyer, however, I will be talking about the experience of a 20-year-old fight. So I'm going to be as brief as possible. To me, judges of the court they knew my history. The sexual assault that I received, I was subject to, I was a victim of in 2002 by the military. I talked about what happened to me in detail. And although in the years that I've been looking for justice, I had to go all the way there because here in Guerrero, they never heard me. The state always wanted to protect the military. For a long time, they had my file in the military justice department, but the army never allowed for their members to be processed by a civil courthouse. That's why the government didn't want to apprehend my attackers, the perpetrators. In Mexico, I was never heard. So thanks to my lawyers and the organizations that have accompanied me and that called me from the court, that was my last resource after 8 years. The Mexican state ignored me, so I had to go to the Inter-American Court where I was heard. They heard me. They knew that I didn't lie. They knew that it was the military who raped me and that the state didn't protect my rights. But I also went to the Inter-American Court so that my children didn't have to suffer the violence that I went through for being part of the indigenous community and a woman. I've been fighting for 21 years, and the state hasn't guaranteed the right of women yet. In my state and my community, well, they still see raped women that never receive justice, that they just mistreat them. In Mexico, there are a lot of mothers demanding for justice for their raped and murdered daughters. However, the government won't listen to them, and the state say that they've already done a lot, but that's not reflected in our reality. Despite the so-called training to military and public officials, they are still chauvinist and racist. Women that denounce sexual assaults, their cases never see justice. For indigenous women, there are no interpreters, and many times they are discriminated for being indigenous. The health services are inefficient. There are no psychologists. The government still give a lot of money to the military and public officials, but not to indigenous peoples and not to the organizations that help us. Indigenous women are still being invisible. When we raise our voices, the state shuts us down. We don't want that anymore. I don't want that anymore. I want for the government to have the will to listen to us. The National Guard has never taken us into account as victims or as organizations. Today, many military members are on the streets committing abuses because they have the entire power of impunity. I think that what the state says that they do is not enough, and they have to prove further will. Especially, they have to believe the victims, and 21 years shouldn't have to go by to apply some sentences or ruling. I ask once again the government to hear for raped women and mothers that look for their children, for the government to guarantee safety and security, that no other woman has to go through what I went through. There are corruption cases in our country and injustice. And in my particular case, the military tried to buy our silence so we wouldn't put their version, we wouldn't question their version and their reputation, because it was not convenient for everyone to know the truth. They wanted to corrupt the facts so that they could protect themselves internally. In our town, we know that the caciques, those that are the ones that have the most money, they have had it for generations, because they are the ones that buy permits for river water, for example, so that they can do their mega projects and everyone has to shut down. There is no objective protection for victims. Those that protect victims are organizations and other international instrumentalities, for example, in my case, the court. In our country, there are many cases of people that are not protected, nor do they have the right resources or the support of anyone that would believe them. That's why there's a lot of insecurity in our country. We are threatened so that we never say what's going on. Instead of protecting us, they wait for someone else to make a move and then they deploy their people. There is no fast investigation. It takes a while. There's not enough staff at the public prosecution office. There are no interpreters either, and they say that you have to look for an interpreter yourself. You have to get your own translators because the institutions, they do not have any. There's no trust. The military won't protect us. The military feel they're superior because they always wear their weapons and they show them to us when there are any raids, they know that they are empowered to do so. We know there are military members that abuse their power. They also abuse their power at home. They commit crimes, but there are no investigations nor punishment. Their own military members and fellow colleagues just protect them. They are not with justice. We have other fellow fighters that defend the mines in our communities, but the military won't let them work freely. They arrest them and they put them in jail and they torture them. When they are able to leave, they are sick or they are falsely accused after spending many years in jail. they are able to leave jail, but when they are released, everyone looks at them as if they were criminals, and the government always says it's a mistake, sorry. Years go by, but the state never protects their people. For example, the mothers that look for their disappeared sons and daughters, no one protects them. They just end up following them and hurting them, and the state doesn't do what they should do. They never protected their children, and they do not protect them either when they look for them. There is also discrimination from the beginning throughout the entire process. As it happened to me, as an indigenous woman, I felt unprotected because we speak an indigenous language. Supposedly, there should be translator or interpreters, but there's never one. If you file a complaint, then you have to walk a very long path to find someone to translate or that can follow the steps with you, because public officials are not willing to do their job otherwise. It is a state that's corrupt, and it does not provide justice to indigenous women in particular. The government hasn't made any effort. In Guerrero, mothers, women, daughters are searched for, but also they are the first ones that are attacked by their partners. We know that this will, if they are public officials, those who attack them, they will never be prosecuted. The government could train their people if they wanted to. They can provide information and confirm that they do their jobs, but they do not do it. Almost always, the organizations are the ones that provide training so that the situation can be denounced. The first thing that should happen is for the state to provide protection to women and to believe women that denounce violence, not mistrust them, nor neglect their testimony, as it happened to me.
For example, the psychologist that gave me some attention at the beginning was like questioning if I was saying the truth or not. They thought that I had invented my case, but it was the first instance where there's a problem because they, as government officials or aides, should not question my testimony and simply not doubt the military's version. And the human rights protectors, those women who are looking for their daughters and sons and community leaders that are protecting their communities, are mainly objects of attack by the state. They're objects of prosecution, jailment, and incarceration. The authorities are not protecting them, but attacking them. And well, it's important for me to say that those who are part of different associations or entities are object of espionage as well. Like the state hasn't acknowledged this, but the defendants are object of this. And if the government doesn't defend them and we file our cases, you have to see what's happening here. And the parties involved in new generations, new attorneys, I mean, the new generations should not, should continue building the light, that spark of life that's part of our defense on a day-to-day basis. You as attorneys should always work under the humanitarian principles and be the defendants of our human rights. Thank you very much. Thank you so much. You're not alone. I just have my emotions. I thank Valentina for her testimony, for her deposition, for her strength, for her struggle. Your fight is our fight. We're fighting for justice here. And now we're going to be talking to our attorney, our professor, Ms. Marta Figueroa Meyer. Even though, I have I am very loud or noisy in my character, in my spirit. As I've said many years ago, we don't have to ask for forgiveness. Thank you very much for opening the doors of this, my home. Being here in this classroom is something that thrills me. I have these emotions. This is the love of my life. When I was like 50 years younger, this this center was my home. And, you know, I was taught by other professors of mine in that stage of my life. They were my professors. They taught me so much when I was here. I was in this institution in September. I was admitted to this institution since 1968, and even like, you know, there's people using graffitis and spray painting, but back in my time, that wasn't really used. There was a process here in Mexico called el Alconazo that was a student movement. UNAM developed me to achieve my license as an attorney, as a defendant. UNAM taught me that path. UNAM taught me law, and it motivated me to become an attorney and exercise this license. When I was a child, when I was so young and I was part of the rebellious crowd, I was 13, 14 years back in 68, I tell you. And Burgoa back then taught me that I can and that we can change those rebellious crowds that are disrespectful, those disrespectful crowds of youth. The first day he saw me, he was like, okay, go wash some diapers, or, you know, my professors told me that we could change things, that things could be object of modifications. And I want to also answer to the question that happened in the previous panel. There was your question. It's our task, civil society's task, and it's women's task to put our body and souls and spirits amidst the process in this fight. Our body is our territory. This is my body and it's my territory. And if I don't own my territory, which is my body, where do I exercise my rights then? This is the path. This is the journey along law. It's the way. And I'll tell you now, quote Burgoa. Burgoa taught me all of this here. Mr. Burgoa was such a correct member. You never saw a wrinkle in his face, not a hair out of place. When Echeverria was there, and Echeverria, the executive, came here to UNAM to declare his speech, Echeverria was always almost of lynching, or in the philosophy unit and the rights unit, and we almost like simply lapidated that man. Yes, I am loud. You know, back then we didn't even know what was happening, but we knew that the executive was there, and we had to kick him out. And he had his detailed bodyguards, and we almost, you know, we got him out. And Burgoa back then simply had to go through the whole process. And he was not just, another comment, and I quote, sometimes the judges or the triers of fact are not object of a defense. And Burgoa taught us with example that we always have to defend what stands as law, the principles. Now, and he said, not here. He said, here, there's going to be no bloodshed. In UNAM, there's going to be no bloodshed. That's what he shouted. And he said, you take him to trial. You take that man to trial. And back then, he had already beaten Díaz Ordaz, who was the president. Díaz Ordaz had already won the amparo or injunction procedure. That resource law is strong. When you give law a face, when you give law that commitment, you're engaged with it. When he went to visit Chiapas, it was paradise. I didn't know that notice that because everybody was like, you know, just simply stripped and without food in that entity. But what's happening here, what's happening with a lack of justice here is no news. But in Chiapas, you know, that's something that they call the intersections now in Chiapas. There's this construct. It's alternative law. It's the alternative means of law with gender perspective, and that has a touch of feminism, right? And back then, I was called like a woman with capacity to be some sort of also use my tricks. You know what I had up my sleeve. I have my PhD, and they called me, okay, doctor, and called sciences, you might say, or you might think. And it was very difficult for me to finally write my dissertation, obtain my license. They took a year to give me my degree. They took a year to issue it. But you know what? This institution, National Autonomous Institution, UNAM, taught me to become a lawyer. You taught me how to become who I am. I'm here as a defendant of law. I'm here to defend institutions, but institutions had a face, name, and last name. And you know what? We had to read. Miss Flores Margadant made me feel that passion, and I went to study the history of law, and I love philosophy of law. And clearly for me, my feminist colleague said, law is for the patriarchy, is for males, and you're going to be object of, you know, who knows what. Males think with their head, and they're the second head, and they're the authorities. Males are the authorities. We have to teach them how to change. And I was taught to be an ambassador of change. If I don't like something, read, study, research, find ways of amendment, of generating amendments to law. Changes happen through citizenship that have a name and last name. And I'll tell you that in Chiapas, in the state entity, after leaving UNAM and after analyzing the critical context in Mexico City, I went to Chiapas. And in Chiapas, I found another group of a collective of women that were simply affected by sexual violations, rape. Today, it's like this wonderful magic town called San Cristobal de las Casas. And, you know, my dissertation was about rape, cases of rape. We've analyzed the situation of the victims. We had to think about how to correlate the sanction or penalty to the individual perpetrated crime or type of crime. We had to find, where did it all start? Valentina, when she gave her testimony, she was questioned. You made that happen. You like that. Okay, those gringas or those Americans are just there running around naked in the hillsides of San Cristobal de las Casas. They're generating or making this happen. We had these principles. These principles led me to work on my path, career path, and I took the lateral routes. I was in litigation in the field of fiscal law, the commercial or causes. And I thought, okay, I'll become an expert and I'll interpret financial statements and balances and analyze a case file and take that to another instance with appeal and injunction. And then I learned this from the Treasury Department or the IRS. And I thought I was in litigation with the injunction procedures or resources, but the authorities. Okay, but we didn't want to be smashed by the authorities, but I analyzed the rights in Chiapas that were customary, and what was the prosecutor and the trials and courts in Chiapas led me to try to change the system, but they just simply threw me to the ground when I tried. I had my license as an attorney, and I had an expertise or an accreditation in injunction, amparo, resources, and the financial law. But my friends in 39 years ago, we were there together in a collective and we started our riot. And they pointed at our collective in San Cristobal because we were marching down the streets because of cases of rape. They called us the Colem women. They called us in the Maya language, Tzotzil. Colem means in the Maya tongue, free or released or unchained. So those released husbandless women are there running around in the riots as Colem. So I started finding the alternatives of law, and I discovered myself as a woman, and I was transformed. I became a prosecutor, and then I became a feminist, and it became a life journey. I was going down that path happy, and I was ready to speak my word. And in 94, like two streets down from my block, there was the Zapatista movement in San Cristobal, and I discovered that I was also part of the indigenous communities, and I was working on a day-to-day basis with poor indigenous community women. They were criminalized, victimized, without rights. They were living without rights systematically. And you ask yourselves, why? How do you generate or create an accusation in a case file? And I stand for women, and I walk with women to the prosecutors to file their disputes like Valentina by me. They have to walk from rural communities to the prosecutors. There's 74 local entities in Chiapas to serve over 6 million in population in a territory that's divided in over 120 municipalities. There's 14 courthouses for oral hearings and trials to take place. 14. There's 23 more. Quantified these, there's mixed causes, criminal causes, civil causes, family causes being heard by those entities. Weekly, imagine the cases filed. Do you think these courts are autonomous, independent? They're appointed to their office by the governor from the Green Party. He's a shame. What a shame. I started my development to obtain my license, and there's affidavits, depositions there. And you see in the trial with the trials of fact, and you can go to your classrooms and read those depositions. And then I understood. Either one way or another, I had to understand. I obtained my license and then I achieved becoming a defendant. And today, I'm a feminist defendant because I will always support and be the company of those who need it. And I've been supporting women for over 34 years, women that have been victimized with all levels of violence in all fields, and women and the rights of these subjects and their access to a fair trial, as we all call it. They don't even reach the level of that phase of a fair trial. I've quantified till 2006 to 2012 more than there were 37 processes or case filed there in backlog that were binding to trial. Think about all the hearings that I've been part of. I've achieved much. The last hearing was on May 9th, and I had the subject appear that was part of the military before the trials of fact. In 2012, you know what we achieved? The first issued ruling. There was an issued ruling, and the trier of fact, who was a woman aide, she used the terms or constructs called feminicide violence. And I asked them to explain what's the type, the criminal causal type, what makes it different, feminicide violence, and the subject that was the active subject, the perpetrator, wanted to be taken to military justice because he wanted that to be taken to the trials in the military courts. He decided to kill his woman, his spouse, because the trier of fact had already given him that capacity to change to military justice, not the civilian courts. Now, my colleagues at the panel and I had discussed this, and it was a case against the military authorities in the state entity of Chiapas. That case happened on January 1st, and by June 4th, we had documented in the case file violence against girls. They had to go through a military checkpoint, 3 girls that were object of violence, sexual violence. And these 3 girls had to face another great professor. But back then, this professor's understanding of gender perspective was nowhere to be found. Mr. Grossman. Mr. Grossman, here in this university, we asked him, we told Grossman, remember, you might not remember me, Mr. Grossman, I was there fighting with you because you thought that those 3 girls that were victimized, discussing, ventilating their issue with their aggressors or the active subject in the communities where these 3 girls had been victimized, you wanted them to narrate how they had been raped multiple times. And you pardoned them? These girls were object of threats. They told them that they would be disappeared if they said something. And Grossman wanted them to narrate that and just at a panel and an open table when he visited. Of course, they told him out. And until we reached the venue, we could discuss it and debate it in a place such as this. Where are our rights, I ask you? And that was a situation that led me to learn so much when I was so young. There's stereotypes, right? We were the rebellious crowd of women that were so different and that we were hot-headed back then. Another professor from the philosophy unit told us, okay, these little girls are here. The little teenage girls with a hot head are here with their moms. And they were giving us catering services, but they called us tortas, or they said that we were receiving tortas from our mothers. But in Ceú, tortas, which is like some sort of sandwich, has a different meaning. When I turned 13, and in these institutions that fight for human rights, women have less rights. Our women are not as important. Women's rights are not as important as males' rights. And I stress on these points. I stress on the fact that we need fair trial, due process based on the principle of which is presumption of innocence. And I stress on that point, which are our guiding principles. There's the immediate principle of protecting those subjects that have been offended or victimized. If the active subject is a major judge or trier of fact in Chiapas, the municipal authorities, if the perpetrator of the crime is his or her father, if he or her is a perpetrator of a crime and he or she is an activist, think about it. I mean, if you're in if you're in a caravan that's fighting in a collective, and this woman was in a collective, and I reference this case because there was a woman involved that did not permit the counterpart to rape her, to attack her. The court resolutions that have been issued, the first court resolution that was issued, and when I was supporting that case, you analyze the response to the offense through the prosecutors and the authorities. When we've heard the case narrated more than once, it's like, okay, this has happened. How much do you want? Okay, your grievances. How much does it cost? How much does your rape cost? That's not fair. So we have to change it. We can change it. How? Here, there's a collective of women. You see Santiago is over there. We debate all of these cases and situations. We ask ourselves, how? For a trier of fact to have a fair trial, we have to analyze both parties, the counterparts, the defendant, the accused, and quote unquote, the subject that has been object of the offense, the passive or the active subjects. In Chiapas, you say the passive subjects are usually women, elder women. In Chiapas, due to what's customary, the anthropologists who analyze our societies justify that, yeah, women were part of the population of Earth, the planet, and in positive law, the enacted law, and the traditional law, and the traditional systems, women are part of this planet, of Earth, of our land. So women do not have the right to own land, the territory, if it's part of the ejido or the community's land. And if you raise your voice and if you protest or say something, that you're classified as a fifi or snob. And some fighters say, okay, women always come here to simply disorganize things. You woman, why are you here? How can you put that colleague of ours in jail? You're part of those social riots and movements, and you're putting our initiative in the hands of government. So you're affecting the spirit of the effort. So I'm that terrible and I'm so loud. You know what? I didn't touch anyone's ass without their permission. Pardon me, sorry for using my descriptive capacity to enunciate this. So in these cases, I didn't beat anyone. I was not harassing that woman. I didn't avoid her from having the economic capacity. I didn't go to jail because I beat that woman in Atenco jails. I spent 6 days outside of the prison system, and what would I do amidst the collective of males right outside? I mean, you know, the senator of the Republic that was part of a case file simply fled and went into hiding because he didn't want to pay alimony to his kids. As a response in a trial, we were persecuting him for 6 years. That senator left, and the president of the state of Chiapas and the local authorities, I mean, there's a shining light of them. There's a shame right there. And there's a shaming case of UNAM. There's this male that belongs to UNAM that left his 5 autistic kids without alimony, without money, and left his wife. What are we asking for as students, ex-students? That subject, that man should also been called to trial. But I'm sure he also filed his injunction or amparo resources and the procedures and phases. That's reality as a fact. It's systematically a reality. If you go to the prosecutors, they will simply not listen to you, not pay attention. You go to the prosecutors, you have to pay me 500 pesos to generate your deposition, to obtain your case file. And it's a Saturday, you know, and if you don't pay me 500 pesos, there's no case file. Systematically done, even in Chiapas, in the state entity. I'll tell you that we and women, when we go to the authorities, it's always our fault when we try to file a cause or a complaint. Because there's a principle of presumption of innocence, and in Chiapas, there's what's customary in our law. In the prosecutor's office in Chiapas, Chiapaneca women, they found their own luck. That's they found that's what happened to them. They fell, they simply stuck a stick through their bodies, God knows how. Women just fall simply because they suffer their accident solo. They fall into a puddle that's a 25 centimeters depth of puddle of water, and they simply drown in 25 centimeters of water. But in urbanized towns, there's an issue that we've watched with the trends of women and what's happening in the healthcare systems with women and with the ownership of assets or deeds. Women are in Chiapas are committing suicide. Oh my goodness, like Digna, right? Like Digna. And we know that we have to change. This can change. And I tell my colleagues, and I tell you all here, Digna Ochoa did not commit suicide. Betty Cariño, she wasn't just being a mad woman without things to do out there. Berta Cáceres, they killed her because she was defending the land. We've just celebrated, you know, so many years of our female activists being object of feminicide. They've been killed. My friend, who asked for justice, they killed her right at the door, right there at the House of Government in Chihuahua. They just gunned her down. When are you going to stop the perpetrators? And Lucha, our colleague, Lucha, we love Lucha and Victoria and our colleagues. That's why I'm here at the panel, because people like Valentina, people like Norma Ledesma, our women are victimized and they become defendants. It's not enough to just be victimized to then become a defendant. You know what she's read, what our colleagues have read, can serve more than a justice. All of you justices, listen to based on this experience. We're learning law. They're learning law from their reality. They have to learn law, but we got enrolled knowing the path that we were going to walk down through. We're in this engagement and we're engaged to law. We cannot just look down. We have to read, we have to prepare ourselves, we have to investigate the cases file. That's the phase of investigation. It takes a lot of work to do that. And it's not just one person involved. Our girls, our youth, so many young students that I've gotten to meet. You know, you're my teachers. These new generations are my teachers. We sent a perpetrator of feminicide to jail, accused, thanks to Luz there. Gabi, Nayeli, all of you over there, all of you are lovely, my dearest. All of us together have given in a very generous way. We have all given our knowledge. People like Ms. Digna, like Ramona, like Ms. Lucha Castro, they have given their life for this fight. Some of these women have been killed. They said that they committed suicide. There's the arguments there. In the Inter-American system to analyze the case file of Digna Ochoa, in the Inter-American Court, they have to reclassify due to the court ruling the fact that wasn't a suicide. It's now an investigation about the homicide. They are not dead. Physically, they're no longer in this earth with us, but in Chiapas, there's the idea that those who are killed, they're the seed. whoever drove forward all these, whoever has given their body and their life to fight for territory and for others, they're not dead. They're not dead. They planted that seed. They're planted in this earth, and we're flourishing. That's why, and I repeat, and I thank you all for allowing me to be present at UNAM. I'm thankful for being at Chiapas. I'm thankful for being with people here in this panel. We have lived together our anguish. She was pregnant with a child that you see is sitting over there. It was a struggle. It was a struggle and almost a circus to find them. And we have to express what's happening with our societies. And I insist, I'm part of this struggle since I was 13. I understand. And I started walking down the path of justice and law and patriarchy, as Ms. Eldia Facio says. We want to transform law into a tool that's really a tool for change, and it is possible. It's harder, though. It's hard to just tackle a judge. It's difficult to fight discrimination, to fight against violence that's exercised in the field of the protection of our human rights here. It's really difficult. It's the core theme then in parallel, it's patriarchy. And if you as women or we as women are not fulfilling the stereotype of being a homemaker, then go out and look for your own luck. If we don't change those realities, there's going to be no fair trials. Because if the woman is like the accused or the passive subject, I mean, think about it all. It's like many of us, 4 years ago, we were working with many women that had been accused of homicide because there was blood relation that had been victimized by structural violence in Chiapas because of specific malpractice during the birth of their kids. So they did not have a hospital to watch over them while they were giving birth. Then the defenders of human rights there thought, okay, these women who go through an abortion or miscarriage are just worse than death. And they were convicted and accused and served over 24 years in life, because they could not give birth properly. And those women still fight. And we listen to their voices through the population in the precincts, and they express their voices to fight for themselves. Now, when you have the defendants, sorry for consuming more time, I'd like to thank you all. And I insist. Lucha, our activist, loves Victoria or victory, and we love autonomy and our territory. So you have to think about women, and what we're struggling for will happen with women, even if we're loud, Thank you so much.
We just want to remain alive. That's all we want. The words of this morning's commissioner sum it all. The proper judicial process should also be a proper one for the victims. It has been a panel full of emotions that bring all of us together, the defenders, the victim of the authorities, and remind us of the humanity that characterizes the fight for the access to justice for the most vulnerable. So unfortunately, we don't have time for questions. We would like to thank you for your attention, and we are going to have a lunch break. So welcome to our lunch break. I'm sorry, I don't speak Spanish very well, but yeah, we will have a lunch break. No, we do understand lunch break. That's mainly it. So yeah, thank you. And those of you who want to ask questions or gossip about Chiapas, everything that's going on in Chiapas, please approach us.
Afternoon for everyone. We hope you've enjoyed a good rest. I know it was a short break, but in this panel will deal specifically with accountability, regarding forced disappearance and extrajudiciary executions or executions. At the panel, we have our keynotes to my left. We have Tita Radilla, who is the VP or Vice President of the Association of those detained here and victims of violations to human rights in Mexico called APADEM. Tita is the daughter of Rosendo Radilla Pacheco and Rodriguez Neri. In 1992, there was a constituted committee of those detained and disappeared in the coast of Guerrero, Mexico. Now, she was appointed as the chair of that constituted entity, and since then on till the present, she has dedicated her efforts to work as a volunteer full-time at AFADM. She went with family members in 2001 with the prosecutors to file lawsuits against specific cases, over 300 cases. She escalated her father's case to the Inter-American Court of Human Rights. And in 2009, she obtained the ruling of Human Rights Commission through which Mexico as a government was accused of the disappearance of Rosendo Radilla. She has been awarded different acknowledgements due to her insatiable work when there's grave violations of human rights in the country. Currently, she's working in a project called Historic Clearance of the Mechanisms of the Commission constituted to find the truth. And to my left, I have Santiago Aguirre, director of the Human Rights Center called Miguel Angel Agustin, of this Center of Pro-Human Rights. Santiago Aguirre Espinosa has obtained his license to exercise law in humanistic studies through the University in Monterrey. He's a professor in LATAM in the field of democracy, social sciences, and she's obtained different diplomas, accreditations through the CIDE Center. She has worked for 15 years in NGOs or civil organizations that fight for human rights and entities called Ciudadanos that support human rights based in Nuevo León, and another center that fights for human rights in Tlachinoyan, Guerrero. Sorry if I pronounced it wrong. He's also worked with a center that fights for human rights called Miguel Agustin Pro Juárez that's based in Mexico since 2019. He's the chair of the Centro Pro DH, which is a Jesuit entity constituted since 1988 that protects human rights in Mexico. Santiago has received different acknowledgements due to his hard work in Mexico and abroad. He's been supporting with his collegiate body, supporting different cases like the Atenco case, the ABC daycare case, Tlatlaya, and other cases that have been filed. To my right, we have Ana Lorena Delgadillo, who is the executive director for justice and the democratic rule of law. She's part of a constituted group that analyzes forced disappearance since May of the present year. She's the executive director and founder for justice in the center. Since that group was constituted, Ana Lorena has worked with other NGOs in projects that fight for justice and the justice for immigrants. There's the Forensic Commission that analyzes the 3 migrant massacres that have taken place in the northern region of the Mexican Republic. She's trying to seek justice for those who are stateless people and migrants in Mexico. She's worked with other NGOs. Ana Lorena has driven forward different programs to have structural changes she's been trying to identify the bodies through the coroners, the prosecutors, and she has worked in programs to strengthen the judiciary branch and the citizens' security. Thank you very much. Tita, the floor is yours.
Good afternoon, respectable members of the International Commission of Jurists. I would like to thank the invitation to participate in this conference on a fair trial. I would like to gracefully salute the different members of the national and international associations that have participated, special guests, and general audience. During the 60s and 70s, in Mexico, there were numerous serious violations of human rights, such as forced disappearances, extrajudicial executions, arbitrary arrests, and torture as part of a systematic policy of a state to limit all of those that considered to be adversaries and enemies, whether they were peaceful organizations or armed groups that were in several parts of the country. In this case, it was the state of Guerrero and particularly Atoyat de Álvarez, where there is around 400 disappeared people. They have been forcibly disappeared, mostly by the Mexican army. During the aforementioned decades, there were no human rights organizations that could support us. However, we started actions to look for family members. We could not able to, we were not able to denounce because everyone was colluded. In 1990, the National Commission of Human Rights was created, and we were able to submit some claims that did not end anywhere. Afterwards, there was an investigation started, and 532 claims were submitted and resulted in the creation of a special prosecution office to address the serious human rights violations in the previous political framework. This was created in 2001 by former President Vicente Fox, my presidential decree. It lasted 5 years, where we accompanied family members to submit claims of their cases. We submitted witnesses, evidences, but this didn't end anywhere. There was no case solved, no victim found, no perpetrator subject to any process, and on November 30th, 2006, this public prosecution office was closed. Since that moment until today, our cases are in charge of the General Coordination of Investigations of the Deputy Prosecution Office in charge of federal crimes by the General Prosecution Office. 22 years later, after this investigation started, family members grouped in FADEM do not have any information on behalf of the CGI about the status of the investigations. And in some cases, the only things that we've received are official documents of non-exercise of criminal action or declining for competency situations without any further explanations. And the worst part is that there were 12 public prosecution offices, and today we only have 3 that are the ones that are in charge of all of the cases the previous dirty war. Impunity has been installed as a politics of this country. The material and intellectual perpetrators have been protected, and public prosecution office have been very little efficient, and it has questioned the capability of the Mexican state to address a historical problem that has been aggravated in the current context of the crisis of human rights that we are going through. The family members of arrested and disappeared people and victims of political violence of recent past have demanded justice without being a priority for the Mexican state until today. They have never answered our claims. We recognize that there have been efforts made. However, these have been insufficient to achieve justice for these serious violations of human rights. More of 5 decades later, many have died without being able to know what happened with their loved ones. Those of us that survive, we are most in a difficult situation because of uncertainty, because we do not know what happened with that beloved family member that disappeared. After 27 years of the disappearance of Rosendo Radilla Pacheco, my father, we had to go to international institutions because despite having addressed all of the legal resources, we never found justice in our own country. Almost 14 years after this ruling was issued, there have only been 5 search diligences without any positive result. There hasn't been any efficient search plan that could find my father and the rest of the disappeared arrested persons. The last diligence that was carried out was in 2019, and it was non-conclusive. Only half of the elements that have to be revised were addressed. All of the different diligences have failed. There is no interinstitutional relationship of those that have to do with this matter. They just try to hinder the progress of this investigation in an absurd competition that affects directly the cases. Impunity has perpetuated in Mexico due to the fact that our country is hurt, full of blood. More than 100,000 people are disappeared today. More than 100,000 families are broken. On October 6, 2021, Mexican state issued a decree by which the Commission for the Access to Truth was created. And to historically clarify cases and to address the impunity of human rights cases that were committed between 1965 to 1990. Addressing the observations and recommendations of national and international bodies in the matter, which we consider to be a positive action. This is why we have been supporting the different efforts that have been carried out. However, we consider that until today, there are no serious, effective investigations to find the disappeared arrested persons. We cannot say that there is an investigation if we don't have any public prosecution office that attests the evidences that have been found. They do not have any legal validity, hence. On the other hand, it has been announced that this year, the remediation were going to be happening individually and collectively. However, until today, there is no proper resource to pay for these damages. We cannot, people cannot be lied to. The victims of these unfortunate situations need the remediations because they took away their family members. They destroyed their lives because they have been living in agony because these crimes were committed by the Mexican state in the framework of the political violence of the past. There is a debt, there is a historical debt that needs to be addressed. Because of the aforementioned, we need, first, to have searches carried out immediately so that these diligences can be done articulated and professionally in a committed manner, putting the victims at the core and in aiming for solving the cases. Two, to create a special prosecution office for case continuity even after the commission of truth being enabled. To carry out investigations to identify and sanction all of those responsible of serious violations to human rights committed in our country during the political violence of the past. Four, to repair according to the international standards the victims of these unfortunate crimes without this turning out to be re-victimizing for them. Thank you. Thank you, Tita. And emphasizing on the need to search disappeared persons and the need to have effective investigations by the prosecution office. Santiago, please go ahead. The floor is all yours. Thank you very much, Carolina. Good afternoon, everyone. It is always a challenge to be speaking after Tita that has been quite relevant for everyone to know in Mexico the reality of forced disappearances. And it is also an honor to share this panel with Ana Lorena and with all of you. I would especially like to thank the organizers and the organizing committee. We truly appreciate that you bring us towards the historical character of Ebru Timtik. We didn't know the story, and we believe that this is a very strong testimonial of the defense of the state of law, of human rights, and we truly appreciate that you can bring us closer to the history of this woman. It is important to present before Dr. Sayana and Commissioner Esmeralda, because she has spent all of this year as a as a rapporteur in Mexico. And we know for a fact that she has always been very interested in forced disappearances. And Dr. Sayana, it has already been discussed before in other panels. He was a member of the Inter-American Court where Valentina Rosendo's Candu case was solved, as well as Bandidos Cortega and the case of Tito's father. So it is always a pleasure to be in the presence of persons that have been worried about the situation of human rights in Mexico. I would like to very quickly refer to the matters at hand, which is the situation of forced disappearances in Mexico. As you all very well know, in Mexico, there is a non-resolved case of disappearances that happened especially during the 70s that adjust to the detected and documented pattern in Latin America in the employment of this practice against political dissidents and their family members, with an important participation of state agents. Without having solved that history, because it isn't yet, as of 2006, we entered a new stage of disappearances that in the current context show similarities to the ones that happened during the 70s, but that also bear differences. These disappearances are framed in three different patterns, at least. We are still having disappearances committed by state agents, not only the federal field and the military, but also state police commissions or municipalities that actively participate in disappearance cases. We also have a huge number of disappearances committed by particular organizations, criminal organizations that are still in control of certain regions throughout the country. And then we have also a huge number of indeterminate disappearances because there hasn't been any control, because they are carried out with the acquiescence of the state. So this is the most, the wider range in the present, because this type of disappearances, the ones by the state, do not really reflect what's going on in the country, because they neglect the dimension of the government being aware of it and not doing anything. So in this current context of disappearances, we all say that we are going through a true crisis in a country. Tito already said it. According to the official record, we have reached more than 100,000 disappeared persons, and these are not numbers that each of these victims cannot really feel, because these are true people, these are faces. And the family members end up being destroyed because of lack of certainty on what happened to their loved ones. There have been histories that insist that this is an isolated phenomenon. There have been also moments where this speech has been facing reality after the victims have acted out. So an example of this was the emergence of a Paz con Justicia y Dignidad movement, where Cecilia and others that came out to public places to put a face on disappeared people. Another key moment was the disappearance of the 43 students of Ayotzinapa at Iguala in 2014, and also the emergence of brigade groups by family members to find their loved ones. Facing this atrocious and overwhelming reality that has overpassed all of the Mexican institutions, the response of the Mexican state was fundamentally approve new legislative frameworks, and as of 2017, a general law in terms of forced disappearance was approved, as well as disappearance by particular groups that wanted to create a foundation, a constitutional foundation that could address this crisis. So the general law was a source, what was a source, it has already been discussed in other panels. In a federal state, we have state laws and federal laws. Here we have a general law in terms of disappearances that when addressing this figure, the attempt was for it to be a national-wide effort. That was the attempt, at least. So this considered the creation of special prosecution offices to provide a follow-up to disappearances at a state level, and it created also the forensic bank institution to be able to facilitate the identification of bodies and remains that have not been duly processed by the public prosecution office. The numbers in Mexico is more than 50,000 bodies and corpses and remains that are awaiting to be identified in the country morgues. Also, a national system of search was created with a national search commission and state search commissions in each of the states. And there was also a creation of the national registry of disappeared persons that could be a roster to bring us closer to the reality of the problem. Unfortunately and sadly, 6 years after the approval of this law, many of these tools and instruments were not executed. The Inter-American Commission on Human Rights, via the annual reports in the Chapter 4, has been providing follow-up to this topic every year, specifically after the approval, the enactment of the law. And these reports are useful parameters to see the huge stagnancy in the application of these instruments in Mexico, particularly. Now, last week, it was announced that the National Registry of Disappeared Persons was going to be revised. And this has to be very carefully addressed because it is being done during electoral times. And in Mexico, we have already seen that due to political more than technical matters, the rosters are fixed so that they can favor some candidates, but we do not want for it to happen anymore. So besides the motivation that has created litigation, besides that, what are we doing facing this crisis? Well, definitely there are efforts by the state. Yes, it's important to mention them, because if not, we are not going to be able to leave this crisis behind. We need the state for this. Anyone that says the contrary is not being realistic, but these efforts are not enough. That's the problem. We have a national commission of search and with a leadership that's attempting to visibilize this problem. However, we don't have a national search system that's living up to the challenge of this crisis. In the judicial branch, there are relevant efforts. Arturo Guerrero, we have the judicial school that has been publishing some manuals so that the federal system is addressing this topic. However, beyond those efforts that we can find in the National Search Commission and in the judicial branch, the huge missing element here are the prosecution offices. While we don't have prosecution offices in every state and at a federal level that understand that we are going through a crisis of forced disappearances and that can act accordingly, then all of these other solutions are going to not be enough. So the only thing we can do is echo the concerns that have been discussed today, especially during the morning, on these attacks from the federal government against the judicial branch. Been pointed as the main cause of impunity in Mexico, at the same time that the disaster that the public prosecution office and the public attorney's office is just neglected. That's only, and it only becomes involved when there is a conflict of interest. So what we have to focus on is the element of the public prosecution offices, which this administration hasn't addressed, and we need to show that they cause impunity, and because of that, they are distorting reality. And afterwards, we can discuss what has to be fixed of the judicial branch, many of them, I'm sure. But first, we have to address this huge and sad impunity hope that the public prosecution offices represent. What else are being done? Well, the efforts by the victims. The first thing that we have to highlight, more than committed officials, more than legal initiatives, is the continuous and permanent ongoing dignified mobilization of family members of the disappeared persons. Today we have in Mexico mothers, sisters, daughters that go out in the field to look for mass graves with their bare hands, and they go there looking for their family members. And we have to embrace them, because those mothers that are searching mothers are also being murdered. We have around 6 murdered, searching women in this administration that they have just been murdered because they are looking for their family members. We also have efforts by the civil society. The Foundation for Justice in the State of Law is also doing a great job about it. We at the Prod Center are trying to do what we can. We accompany families, but we also get involved in litigations that attempt to denounce and make the legislation stagnancy change. We just won, the public prosecution office, a long battle with Olympia Montoya, the sister of a disappeared person in Guanajuato, to force this National Bank of Forensic Data to be created. This is an instrument that could be used to look for disappeared persons in Mexico. There is also a huge effort on behalf of journalism. We have Marcel Durati and the website, where do the disappeared people go? This is a benchmark for everything that's been done to visibilize the crisis of disappeared persons in the country. And definitely there is a lot more to do. We have to use technology more. We have created a webpage that's called We Are Not Only Files, and it attempts to provide legal formats for anyone that's aiming for it, because we are not able to provide legal assistance for free, a quality one for everyone. So this is a website that provides formats to those that want to do something as basic as ask for a DNA tests between their loved ones and the remains found at the prosecution offices. So there's a lot to do in the matter, yes. And today we have schools, associations, and institutes being together here because they know that there's a lot still to do. We could provide quality legal aid for free. And this is legislated, but in the different states, the family members do not find anyone that can process this request, because the mothers sometimes are the ones that are more worried about it, because they are worried about being able to find a way to help everyone that has been left behind once their family members have disappeared. So we have to remember the case of Cudberto Ramos as well, one of the disappeared boys of Ayotzinapa. Cudberto is from Matoyac, actually, from one of the nearby communities, nearby to Tita's community as well. Cudberto, similar to Cudberto's case, there is someone that disappeared in the 70s in the context of the Dirty War. Then the generation of the mother and the father came, then Cudberto disappeared in the context of the war against drug dealing and drug lords. So we see that the crisis of the disappearances during the 70s interrelates with the current disappearance crisis now in the same family has happened again because of the war against drug dealers. So we don't know what's ahead of us, but if we still have a Mexico where it is possible that one same family know how atrocious forced disappearances could be in two or more successive generations, then we are failing as a country. There's no democracy in this. So that's what has to change. And for this to change, we need for more people to be aware of the size of this crisis. And it's always important to remember that in this academic household that has given so much to the country, so that young people that are receiving an education as lawyers could provide their technical capacities at the service of this cause, which is the cause of all of the entire country. If not, it should be to reverse the crisis of disappearances that we are having today. Thank you very much for your attention. Thank you so much, Santiago. We would also like to focus on the prosecutions. They have to work. They have to function. And it is very interesting what you just told us about the webpage. We are not just case files, because this also provides legal aid in general. Please go ahead. Thank you very much. And first of all, I would like to thank the organizers for inviting us. And I am very honored to be with Ita and Santiago to be sharing this opportunity, as well as my dear Carolina, that we are having some alliances together, actually. So the first thing that I find to be very relevant is framing, because I was asked to talk about what are the main institutional and practical problems that we find when we want to investigate cases of disappeared persons, executed, and murdered persons. And Tita said it very specifically. We have a country that's hurt. We have a country that's hurt with more than 100,000 disappearances for the previous administration and the current one, with more than 776,000 homicides. So this could appear to be an armed conflict for any country. This could be an environment of an armed conflict, not really declared or official one, but what the territories is going through, well, it would appear that it has been seized by the organized crime. One of the things that I was considering today, trying to understand, so we could provide some context, especially for those that join us from other countries, is how many organized crime groups we have in Mexico and all of the territories they are at. If you see that map, you have a territory that's practically seized, a country that's practically seized by the organized crime. And in the midst of this, there's an impunity that is more than 95% there. So this gives us a picture, a snapshot of the country. And I wanted to start by highlighting what the Committee Against Forced Disappearances already mentioned in the report they gave from the visit to Mexico. So picture this, the committee called one section of the report the following: Mexico and almost absolute impunity. That's one of the sections of the report by the Committee of Disappeared Persons from the United Nations. And they are not wrong, because when the committee looks at more than 95,000 disappearance cases that were reported at that time, we are around 35 rulings only. So this talks about the state of things. And one important thing that the committee did was putting at the center of the report impunity. Impunity features the core of the report. And we cannot talk about this if we do not put the prosecutions at the core of it. And when the committee says that Mexico is going through a historical impunity, I mean, they're talking about the impunity that we have been carrying over since the historical cases that Santiago just mentioned of the 70s that were never solved, these cold cases. So we have been carrying over historical impunity. And evidently, as the committee just said, any attempt that you have to implement preventive or precautionary measures, they're just drowned, because when there's impunity, then the message that they send is that violence is allowed. So it doesn't matter if there are preventive policies. The most important message is that in Mexico, disappearances can happen, homicides can happen, because there are no consequences. There are no consequences. Marcela always talks about John Gilbert. She always quotes John Gilbert saying that in Mexico it's way easier to commit. I'm like Chespirito, I forget what I wanted to say. But well, in Mexico, it's easier. No, in Mexico, it's easier to die. No, Marcela, what did you say? Remind me, please. Now I forgot. In Mexico, it's more dangerous to investigate a crime than committing it, because those that commit it won't see any consequence. So this also talks about what you are facing if you want to investigate something, especially what we see happening with the families. And I think that of the things that the committee has also highlighted, it also puts the militarization at the core of everything, because it, of course, is a factor that violates human rights. And a judicial branch that hasn't, yes, they've done some efforts, as Santiago said, but that they haven't yet been at the same level of the amount of disappearances that we have in the country. They haven't been able to address them successfully. So what happens if we analyze this, putting the public prosecutions at the core? You will remember that we had this adversary system where the idea was knowing how to operate an adversary system, but we left out one of the most important things, which is that institutions first had to learn how to investigate. That never happened. When we had all of these part of the support from abroad to implement the system, we neglected investigation capacities. So the consequence was a series of counter amendments to the adversary system that were more like a warranty, because we needed to help the public prosecution investigate because they didn't know it and they still don't know how to do it. And those that know me will say, oh, she's going to start talking about the public prosecutions like a broken record. But I think that that's where most of what's going on in the country lies. There was an attempt, yes, with the arrival of this federal administration of changing the public prosecution. Those of us that worked in this collective group were already collecting throughout the entire region of Latin America the best practices, especially to face transnational criminality. And we have it just for memory, of our memories, because we had Claudia Paz, we brought public prosecutors from Peru, from Chile, we brought them from everywhere in the regions so they could tell us how to change the public prosecution practices. And we went to the Inter-American system as well to propose that we had to start talking about the public prosecutions, because it was not enough to talk about judicial independence if we didn't talk about the public prosecutions, because something was missing. With Dr. Garcia Sayan, we also talked about this a lot, and the need to have clearer standards to demand the public prosecution. There was a first autonomous public prosecution law that collected 70% what we were working with different collective groups. And then there was a general attorney appointed. And I want to talk about this because the appointments thing happens and affects everywhere. We have an appointment system that's made to serve the different powers, true power. And in Mexico, normally, those in charge of the prosecution offices are people that are close to the executive branch. We haven't been able to separate the executive branch and other powers from the prosecution offices so that they are truly at the service of victims and institutions. When the Gertz Manero came, that issued a report called 100 días, 100 days, he's saying that he found a public prosecution office that was practically destroyed, that was at the service of those that were in power, and that was made to prosecute those that were enemies of the current power. And we were like, oh, if he's seeing that, this means that he's going to transform it, that he's going to change it, but that never happened. It was just wishful thinking. We used to have at least an intermediation with the prosecutors. We used to have a communication. We started to try to create a transnational system with migrants situation that would help intercommunicate with other family members. And we worked with different instruments that, for example, the one that allows the consulates and embassies to directly receive the families so that they can file complaints. So there are no intermediaries. We started creating things, but now we don't even have the possibility for the prosecutor or the attorney to receive family members. The minimum thing we had, we don't have it anymore. And what we are going through is a lack of articulation of many elements. So with public prosecutions that are not autonomous, for one, there are no plans for criminal prosecution, which is one of the things that we were asking ourselves, like, why aren't they investigating what affecting us the most as a country? If you see the Mexican reports, like Mexico Evalúa and other reports, what they say is that the General Prosecution Office of General Attorney's Office is judicializing crimes such as the weapon possession and drugs, but they are not trying to understand how to fight this macro criminality in the country, nor they are connecting to the region to understand how to do this transnationally. There is no accountability. We haven't been able to make the prosecutor be accountable before anyone. When we ask for this before the Senate, they don't do anything either. They do not subpoena this person to be able to be accountable, and all of the mechanisms that were put into the law, for example, citizen participation and other control mechanisms. When the prosecutor came, the first thing that he did was change the law. So he dismantled all of these things that we implemented in the law, or that we added to the law, so that we could have a way to demand for justice.
So then we continued with this fragmentation in the investigation, so thorough vetting process. That's something that we have to think about, because we're driving these initiatives forward with a prosecutor in their field of expertise, but there's many prosecutors that are not communicated amongst themselves. And something that was proposed through the actor law was to constitute multidisciplinary teams that kept their right level of expertise that's required, but they should work jointly, and they should be capable of working with other prosecutors located in other state entities. That's not material. That's not factual. We want the prosecutors to work together. And when there's the intervention of the military, Santiago Tita, you can tell us what you've lived through and with others. But there's been migrants being massacred, gunned down. We supported those issues, or we were reaching the crime scene where there's findings, and the military members were there. We haven't obtained information of the evidence of the bodies or the basic case files, basic documentation from the coroners. Now, the lack of collaboration between institutions, it's incredible. When the forensic services, the coroner services have been serving the prosecutors and not serving the truth, honoring the truth. In Mexico, we haven't seen forensic services really serve science and the science community as the truth should be. The forensic or coroner service are corrupted to confirm theories that have been organized or created by the prosecutors, like the Ayotzinapa case file. But we've seen that in the other cases where there's massacres of immigrants, where the forensic experts simply materialize evidence against the research. There's just a case file in paper. We have the adversarial system. We have all the cases filed with pages and pages of investigation trying to prove that they're investigating, but there's no field work. Field work out there is something that's executed by the family members of the victims, and it's clear and evident to us. And with my announcement, I'll close my argument in my participation. We have a system that administrates justice, in the contrary towards the victims, and they see that the parties that have been victims are not just their allies. If you go to any prosecutor of the country, as you communicate with them, it's like, I have to work as a prosecutor with the victim and the representatives, because they will help me build my case file and reach conclusions. We've seen situations in some cases when we face efforts with the Guatemalan prosecutors. We analyzed analog cases of the Peruvian prosecutors. We're building a team for investigating the cases with the victims. And there's other cases where the prosecutors participated, and we see that the prosecutors do collaborate with the defendants and the victims. Here, the victims want to defend themselves. The system works against the victims, and we have to be very mindful and thoughtful about this. We're reaching that level in time when we've built the instruments to fight organized crime, the public enemy. These instruments are being used against the defendants and the victims. So what's left? We're reaching that level. And these subjects the criminal system and the instruments have been built to be used against the ones that are defending the victims. And we have to see which are the best tools that the state has. The parties might not even move if it's not convenient. It worries us. With Arturo Guerrero, we were thinking and talking about the cases of immigrants. The judiciary branch should be working ahead of itself, trying to work on the basic, the trial of amparo, the injunction mechanism. It takes us 8 years just to obtain certified copies, and we're wasting our time. And just the basic procedures to acknowledge who's the victim. We have to go and try to litigate and impose a litigation against SAP to know who's the victim, to protect the victims with the right measures. We have to open a case that's litigious in nature to see who's who, the defendants, the victims. The judiciary branch is not yet at that level with the measures. With Carolina and I were talking about this amidst the pandemic to open the instance of a amparo or injunction. If we create a system that depends on solely on our attorneys, then that system excludes any other stakeholder that cannot have access to that justice. Now, in this, I think I ran out of time, but we have a Q&A, and we can speak about the positive side of things and what we can actually do. But I want to close with this following argument. If our prosecutors are corrupt, if organized crime permeates and criminals are organized and it's institutionalized, if the police forces and the army, the National Guard as entities are corrupt, it's going to be a major deal and very difficult to tackle for disappearances, executions, and any crime perpetrated. We need control mechanisms that are functional. You know, in our prosecutors, we're trying to see what to do with internal affairs, the police of the police during the prosecution. So we haven't been capable of moving forward, even with our commissions that have been constituted to protect human rights. We had the resources of injunction or amparos, and right now we cannot escalate and impose the resource of amparo with the human rights commissions, with the prosecutors and the stakeholders. I mean, there's a National Human Rights Commission there. We need to order out the control mechanisms so there's a positive consequence in our country, or a negative country output for those who do not investigate and those who do investigate in their diligence or task. Thank you so much. Thank you so much, Ana, because during your participations, we understand how relevant it is to fight for justice and a fair trial through the judiciary branch. The prosecutors, the capacity to investigate in a criminal case are central for due process and fair trials and access to justice for all the citizenship or all the people. After having heard this, we're going to open the Q&A, a question and answer phase. We expect your comments or feedback. We have just a few minutes left for this Q&A, so please prompt all your questions, whoever wants to participate. Yes, hello, thank you. First of all, and I'll be brief, I congratulate and salute you, and I congratulate you for hosting this event in which we're celebrating the International Fair Trial Day. And in this ceremony in which we will award the Ebru Timtik Award. Now, I want to express my question. I want to be very mindful. You know, as part of the Solidarity International Coordinator entity, we're working for the political prisoners in the world. And in the entity I work for, we have shared the following in correlation to the subjects in free trial subjects. The Mexican state has, with the Supreme Court, continued justifying a policy of prosecution, persecution, forced disappearances, and executions. Some social leaders or activists have been well thought of as criminals and people that work against the state, and they're denying the political prisoners. You know, there's the state or the government holds its power or its truth through power, even though there's been amendments to the criminal codes to severely sanction those parties who are accused. There's social protest through criminal courts with a public enemy. In this government, the former administration, we have not been capable of transforming the judiciary and the powers, and now the power is in the hands of the ultra right wing. I have a question in correlation with what I've said. Apart from political stances or grounds, or whatever's political in that political arena, we think about what's happening in this event. What I think is important to mention is that the prosecutors do have problems. We think about how to respect the fair trial due process in the case of people who are politically affected, and they've been in, serving time for over 8 years, like the cases in Oaxaca. There's some cases filed that we defend, like those people who have been against politicians that have been incarcerated. So the prosecutors are not in compliance with what should be procedural. They cannot just close a case, and they're there's sentences being issued. So we speak of the needs, the internal affairs or the police of the police has the mandate to continue monitoring and surveilling what's happening with the prosecutors or what the prosecutors and others have to do. What we see is a macro analysis. The judiciary branch and the Supreme Court cannot just wash their hands and say that the problems are at the local tribunal levels or local court levels. These other two entities have to continue supervising. But in Oaxaca, we had the case with the Oxochitlan subjects that have been taken to trial, and there is no sentence or ruling issued by tribunal. So now they're object of torture. And I'm going to pose a question now. And it's my question. I have these doubts, and the family members of these victims or these people or the accused are asking us. So the power of the judiciary, or it's like being a trier of fact and a party in a case. Like there's corruption, there's delays in the trials. So there's many cases. So what can we expect? How can a body or an agency of the judiciary branch can correct its wrongdoing? Which are the tools for the population to use when a judge is corrupt, when a judge receives an order from the president of the electoral president or chair, as it's been ventilated in Oaxaca, they filed charges or opened lawsuits against Eduardo Pinacho. Now, if that president is completely armored, he's untouchable, there's no corruption there. There's a saying, where there's water that does not flow, it tends to rot. These people have not been touched, at least in the state entity of Oaxaca. They don't even want to affect these authorities. We're talking about 6 people here that are object of torture by the powers of the government or the state, specifically the judiciary. That's my question. If you want, we can listen to a couple of extra questions, and then the questions will be answered by the panel. Back there. Yes, good afternoon. I thank you very much for expressing all your thoughts. Now, and being mindful, I want to ask you the crimes perpetrated. My name is Maria de la Luz. I'm part of the Observatory of Feminicides in Mexico. We're talking about common crimes, We have been fighting for many, many years, along with the prosecutors. The prosecutors are there to serve, and we're betting on that. We're betting on change. We're thinking about re-engineering the apparatus in this country. We've been working a lot to reach a level of autonomy. The prosecutors should work in autonomy and independence, but I'd like to know if there's a case of reference of a state prosecutor where there's progress, because we've been fighting, to achieve autonomy at that level, but we haven't seen material thorough changes in the prosecutors. But is there a case of reference in any prosecution that has really progressed? Because sometimes, the whole landscape it's desolate. It's terrible. We're working, and we've been working a lot in different territories, and we know that the work we have to execute puts at risk what we do. We're at risk. So we have to understand, where do we have an opportunity? Where are things really changing to drive the change forward, to trigger it? Because we say, okay, we've worked so much and we've worked so hard with little results. So I'd like to know in full scope if there's progress somewhere to move this forward, because that's part of civil society. We have programs, initiatives, protocols, laws that are not material, that are not implemented. So why drive it forward? And the mechanisms or instruments that we have to continue observing, or the mechanisms that we have to control, are the mechanisms that are obstaculized by even like the authorities. Can you give me or facilitate the microphone to the next, your colleague that's right in front of you? With this, we close the round of Q&As. Thank you so much. First of all, I add myself to congratulating you because of this great debate. Thank you for having this room for debate so we can discuss matters of such relevance. As you've said, it's not just numbers here. It's not just about cases filed. It's not just about press releases or print. We're speaking about people's lives, our citizens, people that are exploited, that are oppressed. So it is extremely important and fundamental for us to open to these types of debates. In the legal field, I can tell you, I'm not an attorney, I'm a journalist, but for me, it's basic to understand thoroughly the process and what's procedural, to be capable of translating this and communicate it to the citizenship in general. These mechanisms are tools, are instruments, and you know what caught my attention? What Ana Larena said about the international cases of reference, linked to what Mr. Santiago said. These are cases of reference that have affected us historically. The disappearance of people, persecution of people that take cases to the judiciary powers. Ana Lorena said that there's other cases of reference that have served us as experiences. You mentioned the Argentinian cases of reference, and I think you're speaking about the dictatorship or the autocratic process or Peruvian experiences. In the Peruvian cases of reference, what caught my attention was it's a situation that's similar to what we're living in Mexico. And in analog cases, we see how many groups of power are simply staying there in the whole structure and all the instances of state. And they are an obstacle. They hinder when people try to have access to justice. Mancela Turati said, it's a terrible problem, and it seems to be something that fosters oppression, it fosters disappearance, and it fosters executions. Now, I'd like to know if you can tell me thoroughly which are your international cases of reference. Could you be a bit more thorough? I mean, the situation is what it is. I mean, it affects our dignity. The situation could be considered terrible in the Peruvian state. 70 people have been slaughtered, murdered, according to the international executive reports, amidst the riots that started in December of last year. The population and NGOs have filed claims where there's forced disappearances, and there's no investigation happening in the cases filed based on what's happened with the riots. So that leads me to ask, how can these people have access to a fair trial? There's Peruvian attorneys that defend those who have the right to manifest themselves. They've spoke about an attorney from the law firm from Mr. Castillo and the firm that defends him. They're being accused as terrorists of terrorism because they're trying to exercise the right to defend people, civilians that are receiving, like Pedro Castillo, and they're victimized. They've been hurt during their mobilizations, and they're held as criminals. And there's reference on analog cases. So the citizenship is held as perpetrators. And when they're trying to defend themselves, they become victimized a second time. So maybe this falls into the shoulders of the judiciary branch. What can you tell us or tell me more about the international cases of reference? And it would be worth their while to have events such as this, in which we discuss international law and fair trial with international courts. And I know that you're going to award a Miss Ebru Timtik, and other cases will we mention, like the Peruvian case. Right now, things are in our hands, and we need a former resolution. One last comment, and then the floor is going to be open for the rest of the panel members who are here with us. Thank you so much. Good afternoon. I apologize, but I believe that, this is important. I'm Araceli Osorio Martinez. I'm the mother of Leslie Vivero Osorio, victim of feminicide on May 3rd, 2017. In this campus in National Autonomous University, this is the moment for me to mention this at the panel. I'm very mindful. A few days ago, Herminia Valverde passed away a few days ago. She was the mother of Mariela Diaz Valverde, our colleague. She was a student of philosophy and arts in UNAM. She has disappeared. We haven't found her. Her mother, I mean, the mother cannot continue searching for her because there was a medical negligence, and the parties involved weren't sensitive enough. And the process and its steps to initiate the search for her and trying to administrate justice in this country, I'll tell you that the case of Miss Herminia Valverde was at all times trying to survive, irrespective of the conditions she survived in, irrespective of the institutional victimization of her. It's an institutional way to harass and affect the citizens or people in this country, not only in this country, but in the world. Let's remember that Herminia is no longer with us. She's deceased. She died looking for her daughter. And our task is to continue her struggle as mothers who are seeking, who are walking together, irrespective of the crime that initiates our long journey. You know, amidst impunity, I must say, and I must thank you, and I must thank the networks of stakeholders that have been constituted, networks of people who are still battling and struggling in a country in which feminicide happens, in this country in which homicide happens. And we have achieved so much, as Ms. Luz said. You know, we have gone through reforms or amendments. We try to find alternative means of justice too, but we believe that we're struggling alone. And if we find places such as this, gives us hope. And we've said, what's factual is we're convinced our pain has to be processed. We have to give our rage dignity. We have to fight for the lives of those who are no longer fighting with us. We're not all here together anymore, but we're not alone. So thank you all for generating or giving us the opportunity to be part of this event in this space and in this university, the institute, the research institute we're in. Thank you, because this sheds light of hope. I thank all stakeholders present, all of you that have been supportive in that search for dignity, in which we aim to have justice, and we don't want crimes to be perpetrated once again. But thank you so much. Thank you so much. So the floor is open for our panel members. So we're going to listen to Ms. Ana Lorena Santiago. Thank you all. We're listening to your final comments. There's many questions that have been posed, many comments, and I'm going to dare say, as a moderator, to ask you last question. What could we do with international agencies, with the international communities to support people that are looking for their loved ones that have disappeared? How can we support their struggle? How can we guarantee their access to a fair trial in Mexico with an efficient system for investigating this? Lorena, thank you so much. Thank you so much, Ana Lorena. I'll try to be succinct. Let's say many of the questions that have been expressed. First of all, what Luz said, what have we achieved? Luz, I think first we have to acknowledge the positive outputs, the achievements here. And what I'm thankful after having listened to Ms. Araceli here, because you're setting the example, you're a sample of reference here of what we've achieved here. When you speak about feminicide, when you speak about violence exercised against women, we have opened arenas to listen to justice. That's been a lot. We've been doing a lot for mothers that are working with other agencies that are struggling and battling, seeking for their people. We have Ms. Irinea Araceli, that's part of Irinea, that you're part of the observatory, which gives hope, as you've said. Now, you're the mothers that have struggled, open paths to continue the battle. You mothers are elements of reference. There's many women or many others that haven't been mentioned here, but there's cases of reference that are extremely relevant, that your cases have helped other struggling mothers to open up to their journey. When there's cases and causes of gender perspective, there's the Supreme Court rulings with gender perspective. Those cases are rulings that have been issued that could drive forward other cases that should be researched. When there should be thorough investigation, when there's gender causes. And the rulings issued of Ms. Carla Pontigo, who was object of feminicide, we haven't spoken about that case much, but there's a theory in correlation to the case about the chain of custody, the chain of command. The Supreme Court ruling states that the prosecutor is liable because they had, or the police forces that were investigating the case are liable, and the forensics are liable. And this escalates to the top or Supreme Courts because those who are in the top levels of the structure and the leads of all that structure have liabilities. It's important. So we have the legal structure, the legislation that has been drafted and developed. We have the General Victims Act. That general law has been drafted, is one of the top laws in the region. It's highly progressive here in the region, but there's other general acts or laws in this country that are used to reference. And you know, Padre Pantoja, as a member, he's a great developer. There's the lawful Mexico and the practical Mexico. We try to tie both types of Mexico. It's what's taken to practice in the field of law should be aligned. And that's why it's so important to work with the judiciary branch as an ally with the control mechanisms. So we see this in practice. So it's material on a day-to-day basis. And we're there for the victims. And if you ask of the prosecution's cases of reference, there's areas where we have analyzed the interesting prosecutors' practices and what leads us to transform. In Chihuahua, it depends on the changes of the former prosecutors' change in rotation. We've progressed in cases of reference. And I go back to the other point. If we don't have the mechanisms to allocate those people in office that are efficient enough in Mexico, and we don't have the effective resources that are mentioned in the Inter-American Convention to allocate those in the structure to administrate in the countries, then how can we impose control mechanisms aligned with the Constitution or in compliance with the international standards, the Supreme Court, in harmony with all the hierarchy? So we think about how you allocate these people in the structure so our institutions function correctly. There's areas of progress, like with Erika Rodriguez, our justice. Her case has been escalated to the Inter-American Court. She's from Oaxaca. She has been called by the Inter-American Court to be appointed as a justice. She was object of violation of all her rights. Her case is filed with the Inter-American Court system. There's a very important facet of this. In her case, has an impact with gender perspective. Before the Inter-American Courts or Justice Administration system, that case file can impact this whole nation. And you know what I can give you is the memoirs of our seminar. This data has been uploaded in the Research Institute. We've learned a lot from the prosecutors in Argentina, Peru, Guatemala. There's cases of reference that shed some light and lead us to progress. The decisions or rulings should not be influenced by politics nor politicians. The rulings should be based on investigations without any bias or influence, because the problem happens in our country, in Mexico. There's authorities that investigate violations, and they should be kept in autonomy. There should be constituted multidisciplinary groups, so these groups work and aid the families of the victims or the victims. They should not be criminalized. They should be on board when investigating with the authorities. And with this is my closing argument, Carolina. We have to continue thinking. There's many mechanisms that are sourced from the Inter-American systems and the United Nations. How are we using science to fact find and find it? In Mexico, the use of science and so much technology available to start analyzing, those graveyards in which we're trying to analyze and cross-reference the data with objective science data, and the borders with migrants displaced people that are suddenly disappearing, there's technology to find people around that have not been implemented. My work group will launch our executive report in which we have new innovations, technology to find people who have disappeared and continue investigating. The technology is there, ready and available to be used for the families, for the prosecutors. We have cases lying there with the testimonial data, but we don't have the examiner's report with scientific objective data. Obtaining those reports will complete our cases filed. There's bookload evidence or the exhibits. So you see, the recurrent file that's built leads us to be capable of sanctioning or acquitting people or subjects who are liable. Thank you for your questions. Thank you for your attention. So I'll begin by saying, and I'll express our absolute solidarity with Ms. Araceli for your struggle, for what's happening in the case with Ms. Herminia. We want justice for your case. Unfortunately, Ms. Herminia could not see in this lifetime the truth, and I know that you're suffering her loss. I want to also talk about a case of reference that happened in Oaxaca, a case that's relevant, the case of Xochitlan, which is a town of Magonismo in Mexico. And now in Xochitlan, in this pueblo, the Inter-American Court has established in its ruling specific precedent about preventive or precautionary prison levels, or what's used in Mexico in the case of Rodriguez Reyes Alpizar. We've heard about some entities that are in that litigation and some who have tried to use their creativity to use the precedent or criteria precedent to see the preventive imposed jailment to see which are the alternatives or paths. What you just expressed is relevant. The federal authorities make the federal judiciary or that steering committee to analyze cases of the federal causes in their nature. In different state entities, then there's that segmentation. And how do the state entities function? The judiciary at the state level or local level has its capacity or authority or dominion, and they can submit their rulings. Now, the subjects of the matters of debate, some of the issues that we have to continue debating in Mexico is the following. If we debate the top institutional design, if the Supreme Tribunal or the chair could preside the federal agencies to impose disciplinary motions for the triers of fact, but at a federal instance or level, the chair of the Supreme Court of the nation could preside the federal judiciary or this other instance in the federal apparatus. Now, that's the nature and design, and it's analog to other judiciary powers, but we still have to continue monitoring each instance. But I believe that if there's a wrongful action from the judiciary at a state level, then we have to analyze the responsibilities or liabilities of the government officials in those levels. Now, the substantive content happens through the other line of investigation with the instance or the resource of amparo or injunction with the rulings. Then what we have analyzed, or what some of us have analyzed, is that there's so much to debate with the judiciary branch at federal level, state level, and other levels. But in the present, we should not be adversarial. The judiciary as a branch should be independent. So we should not enter into ridicule debate that affects our institutions. Now, with the prosecutors, what has really helped or worked based on the experience is, I know that there's other cases of reference, but besides what Ana Lorena said, what's relevant is what Mexico is doing. Mexico goes through its executive report yearly, and its finding reports, we analyze the best practices in the prosecutors. Of course, there's best practices when there's constituted groups in the prosecutors to try to fight complex crimes that have been committed. Specifically, when this has been designed and the cases have been filed with or submitted to the coroners, forensic science, and the police forces. Now, all of those reports, based on experience in our whole structure, leads us to analyze how precarious the system could be. The administration can change in that structure, the policy changes, and it's not long lasting. And, you know, the work of civil or NGOs, civil organizations, I mean, we all want a decline in the crime rates, but the prosecutors we have to work and change the prosecutors bottoms up. We're working on improving security, and we know that the country is being militarized. We mention all of these issues because that's fact. That's reality. And if we don't have laws that generate a decline on complex crimes perpetrated that affect our society, all of those other efforts to re-engineer, I mean, will not be as positive. Like as Anna said, right now we're mature enough when trying to continue monitoring our institutions to know that if a protocol will be adopted or an instrument will be adopted, then there's simulations and those templates we have to submit the progress reports. We need to be capable of measuring the indicators and the cases that have been open to investigation that lead us to obtain a court ruling that with the accused parties. I mean, we have to investigate the crimes. If we don't follow the process, that it's of no good. Now, I'd like to say, like, what should we do at an international scale? What's fundamental for us is to continue helping the international mechanisms and the international community that is present here through the embassies. The embassies here should understand how complex the situation is. The embassies and other agencies are not that willing to speak about all of these situations because they have their international agenda or national agenda, and we have to continue working in analyzing a situation such as the Mexican case. In Peru, we're not experts of the Peruvian cases, but there's the Inter-American Executive Report that was published on May 2023. In that executive report, there's grievances or violations of human rights. So it's very important for us to understand that the Commission, the Inter-American Commission, could lead us to understand with the reports which are the acceptable parameters to communicate the situation of Peru, Nicaragua, and the situation of other economies in the region. They're facing a complex context. That's mentioned in the convention in the 4th chapter. That's why we have to defend the Commission, and the American states are involved, and the Inter-American Commission has saved lives in Latin America. The Commission has helped us, and it must be defended. There's going to be an election process in which we'll select new commissioners in that commission. So we're going to all cast our votes to see what's going to happen. There might be some Mexicans elected, and this has been discussed. What I'm going to mention has been mentioned in other tables, but Ms. Lucha Castro has been an activist that has struggled and fighting. She's been fighting for human rights in Chihuahua and Oaxaca. She's also struggling and fighting there. I know that she will be victorious, and we're glad we've mentioned her in this venue.
Now, question-wise, I am not an expert, I am not a lawyer, but I would like to, of course, join our friends in their grief. What Araceli just mentioned, the cases of our friends that have been executed, murdered in this administration because they're looking for their loved ones. It cannot be that this is still happening. This cannot happen anymore. It has been very hard to us because we are in this fight together. We are fighting to find our loved ones. We are fighting for justice. These are cases that are historical, as they say, but the families are there. I mean, the case is still there because we haven't stopped fighting for many, many years until today. We are still fighting. And we are also accompanying in the National Search Brigade. We are accompanying our friends that are looking for their loved ones in this very serious situation for the families, for our country, and nothing is being done to find them. It has been very hard to see how the families, how mothers especially, they just scratch the ground. They look in the hardest places trying to find their loved ones with their bare hands. And unfortunately, they have found many remains, but they haven't been identified. Many of them are still at the forensics offices, and it cannot be like that. It cannot be. And I want to tell you that in my father's case, the ruling has not been met in its entirety, especially when it comes to the search. The public prosecution offices have denied. Have I don't even know how to say it, how to put it, but they just won't do the due diligence, what's needed to find not only him, but the hundreds of persons that disappeared with him, you know? And a journalist asked the president, the current president, and the president said, "It's okay, that's solved. It's okay, don't worry." Well, it's not solved, and I don't really know how to say it. It's absurd. It's absurd that he's denying the problem, and what this morning speaker just said. What he's doing is just absurd. His answers, the way he responds is just absurd. So what can we expect of this administration? The situation is way serious. Disappearances happen every day. And I don't know where we're going to go from here. What's going to happen? I don't know. Thank you very much. Thank you so much, fellow panel members. And with this, we would like to conclude this panel. We are going to have a brief break. And afterwards, we would like to invite you to the celebration of Ebru Timtik's award ceremony. And I would like to tell you that in this panel, there will be two English-speaking persons. So if you want to ask for headsets, please go ahead there in the back of the room. And thank you very much. And we will meet again at 4:40. 4:40, please. Why are we looking for them? Because we love them. We will continue until we find them. Because they were taken alive, and alive we want them back. Because they were taken alive, and alive we want them back.
Buenas tardes, colegios. Si aún no lo han hecho, por favor,
Good afternoon, colleagues. If you haven't asked for simultaneous interpretation headsets, please go to the back of the room because there's going to be presentations in English, and I will be speaking English as well.
Good afternoon, everyone. It is my pleasure now to open the final part of today's International Fair Trial Day ceremony, namely the 2023 Ebru Timtik Award. My name is Eleonora Scala. I'm an Italian lawyer working as program coordinator at the International Bar Association's Human Rights Institute, which is one of the organizations behind this initiative. And I would like to welcome all the amazing panelists that we have here on stage, but also online. We have Mirta Fernic, that is connected from New York and should be virtually with us today. As announced earlier in the day, when the International Fair Trial Day initiative was established 3 years ago, it was established hand in hand with the Ebru Timtik Award. And the award has been created really with the aim to celebrate the courageous work and the achievements of individuals and organizations that have shown exceptional dedication in safeguarding the principles of fair and impartial justice in each year's focus country. And on top of the recognition of their bravery, this award is also to send a clear message to human rights defenders all over the world that the international community is grateful and supports their efforts to promote fair trials for everyone. And with this in mind, we are particularly honored to have here with us today as keynote speaker, Mr. Diego Garcia Sayan, since through his immense expertise on judicial systems at large, but also of the specificities of the Mexican system, he will be able to shine a light on why this initiative matters and why these types of recognitions matter. Mr. Garcia Sayan is the former special rapporteur on independence and judges and lawyers, former president of the Inter-American Court of Human Rights, and in Peru, he served as Minister of Foreign Affairs, Minister of Justice during the country's democratic transition process, And of course, he covered many other roles in international organizations like the United Nations, but also the Organization of American States. He's the author of several books on international law and development. And it is an immense pleasure to have him with us today, opening the ceremony. And we want to thank him for being here. So Diego, please, the floor is yours.
Gracias, Eleonora. Amigas y
Thank you
amigos.
so much, Eleonora. My dear friends, it is a pleasure to be with you today. It's an honor to have been invited by Divari and so many other organizations, relevant organizations around the world for the defense of justice and human rights. And it is a pleasure and honor to be with you in this friend home. And we all know the name and the last name of this institute, one of the most important in the world and in Latin America, of course. I am very honored and moved after everything that we've been listening this day. I am so honored for being invited to address the fair trial and the ceremony of the Ebru Timtik Award, which is closely interrelated to one another. This has been a great idea. This has been a topic that has been addressed for third year in a row, as it has been mentioned during the introduction. I find it relevant to bring back the name and the life of Ebru Timtik because of life circumstances. I was the special rapporteur on the independence of magistrates and lawyers of the UN. So I received the official invite to visit Turkey as a special rapporteur. But the rapporteur can only visit a country if an invitation is sent to them, as you very well know. So I followed the case closely and I sent communications to the government, public communications to the government, because Ebru Timtik was one more victim, one of the most visible ones of a wave of repression that was affecting thousands of people as well. Ebru was sentenced in March 2019, along with many other people. I think her process included other than 17 persons, but it was a phase of a lot of sentences. And she started some months later a hunger strike with the known results. She died after a long period of time. There were a lot of communications that were never addressed. She was brought to a clinic, to a hospital, but she unfortunately died. So Ebru Timtik became a symbol of bravery, of courage, in front of a policy and a series of repressive actions using private justice of independence, because in that prosecution, many lawyers and many judges fell. They were fired and they were made prisoners, and many of them are still imprisoned. The tireless work of Ebru and many other lawyers was important. It is still important nowadays in a process of democratization that is still pending in Turkey. This is why we would like to remember her and make her symbol a core one for conviction and for the dedication and a cause for human rights, which is very important. With this introduction, it is important to mention that the aim is to find a specific country to grant this award. Last time was in Egypt, if I remember correctly, although there was no ceremony in Egypt because of internal political situations. But today we've heard many things that have been said about the current situation in Mexico and the perspectives of the questions that lie ahead. It's important to mention, of course, that it was a joy for me to be able to find Valentina and Tita Padilla again after seeing their case at the Inter-American Court in 2020, one case and the other one in 2012, as far as I remember, and seeing that in the sentence execution process, there is relevance. There is relevance for this topic to continue. The state is obligated because the inter-American system, I don't know if it's randomly or by accident, it is best that the European one, because in Europe, when the European court dictates a sentence, a ruling, then it's a political situation and probably it's not given any further follow-up. The Inter-American Court, after 10 years, they still ask the Mexican state what happened with the ruling, what happened with the ruling. I need a report. So I need that this is important to be acknowledged, to know if the results have been achieved or not. This is why being Mexico, the venue and the place where we are gathered here today, and having people here that receiving an award, people that have fought for human resources in this dear country, it is inevitable to readdress what we've been listening today. It is a friendly country, of course, an amazing hospital country, but there are very deep wounds at an institutional level that affect the rule of law and that affect what has brought us here today, which is a fair trial and the right for a defense. This very peculiar and specific figure has been referred to, the preventive custody. And this year, the Inter-American Court has expressed that preventive custody is out of the Inter-American legal field and it should be eliminated. And that's one of the reasons why we are gathered here today. But I don't really want to turn this into a conference. It is just a comment because we are going to discuss the awards. But talking about a fair trial, it is important to sum up that just as in Mexico, in other countries, we have different threats that come from the political branch against a judicial independence, against the right to fair defense, and as it was said earlier on, the functionalities of the prosecution office to investigate independently serious crimes and serious violations of human rights. So the actions by the state bodies that should be improved, that should be fine-tuned so that we can truly talk about a fair trial, the right to a defense, and to guarantee the legal profession. But there's another source that also affects these rights and that prevents fulfilling these warranties, which is a growing situation in many Latin American countries as well as other regions in the world, which is organized crime. The facto powers that exercise by themselves a criminal activity, threats, homicides that, of course, do not free the state from the warranty of having to protect under those situations, but sometimes where criminality acquires so severe characteristics and so huge characteristics, it makes it for human rights to become one of the greatest challenges and threats lying ahead of us. I will share a very brief story. As the first report, as a special rapporteur, I enter that the United Nations should be one of the elements having to do directly with human rights, because it establishes how countries can coordinate their justice to face corruption. Of course, we need to have independent judges. They have to be honest prosecutors. So this is a matter that is directly related to human rights. But there's a level of bureaucracy in Geneva. So they told us that they was not a matter of Geneva. Geneva and human rights is just a matter of Vienna, and it's a matter that has to be seen there. But I'm like, it's nothing to do with Geneva or Vienna. It has to do with international human rights. So there's an element that has to be further developed and discussed. It is a challenge, and part of what we're seeing is that there are growing power control spaces that are not in the hands of the states or the federal governments anymore, or municipalities. Of course, this does not exempt them from responsibility, but this is something that has to be given growing attention. And as it was mentioned earlier on, maybe we could find their answer to some of the concerns, especially where are the disappeared persons, who took them and why. These are pending matters to be investigated, but this needs of a fair trial. This needs judges' independence and it needs capacity of action from lawyers. That's why it is very timely to discuss those values, those principles, and to be able to incarnate them in persons with a face, with a name, with a long-standing career. I think that Ebru, she was 32 when she died during her hunger strike. That was very painful, that was terrible, but as we're seeing here today, it was not in vain, and it left something behind. And of course, it makes us ask ourselves who deserves this award. There is a huge list of candidates, eligible candidates, and the selection process where I didn't participate, it must have been hard. Some amazing conclusion must have been reached. I already know who they are, but I am not allowed to say who they are. I cannot even hint them, but it's amazing what they've done. I think that this incarnate in a name and a last name could be an example for persons that are struggling today, that are fighting today, so that they can say, okay, this is going to be useful for me, it is going to guide me, this is going to help me. We've heard people that are fighting, like Tita, that has been fighting for years to know what happened with her father and with herself. So thank you very much, Leonora. It is a pleasure to share this panel with Serife and with Rocio. I would like to congratulate the organization, and I would like to I won't even say the gender. Congratulations to the persons that will be awarded in a couple of minutes. Let's follow their example. And I'm sure that Mexico and all of the countries will be in better conditions and will reaffirm their rule of law and everyone's rights. Thank you very much.
Thank you very much for telling us more about your personal engagement as a special rapporteur on Ebru's case, and for bringing together all the discussions that we've had today throughout the several panels on the Mexican justice system, its flaws, and also the main critical areas where the domestic and the international legal community really needs to focus their efforts on. And against this backdrop, I would like to introduce my colleague from the steering group behind the organization of this initiative, Ceren Uşal. She's co-secretary general of the European Association of Lawyers for Democracy and World Human Rights, that many of you might know by the acronym ELDH, an executive member of the Progressive Lawyers Association, CHD. And being a human rights lawyer from the Istanbul bar, she will be able to tell us more about Ebru Timtik, whose profile you can see here standing in front of on the desk, and how it happened that her story, her struggle became the image for this really struggle for fair trial rights, not only in Turkey, but also beyond Turkey. So, Ceren, the floor is yours.
Thank you, Eleonora. First of all, I would like to thank you all for being here. I know that it's a long conference, and thank you for staying here until the end of it. And I just want you to know that we are not alone right now. We have more than 70 people who are connecting us via Zoom, and it is important to know that it is 2 a.m. in Turkey, and probably more than 50 of people are listening us from Turkey. I brought you the sincere greetings of the lawyers in Turkey, especially the lawyers from the Progressive Lawyers Association, who is that is my association, but that is also Ebru's association. They are listening us right now. So I think this is one important aspect of this award. This award is a bridge between people who are fighting against injustice all around the world. Of course, I do not know how people in other countries decide to become lawyers, but those who decide to be a lawyer in Turkey are divided into 2 groups. The first group actually chooses a profession. They are looking for a secure job, just like any other person everywhere else needs to do, and they choose to become a lawyer. This choice does make them neither good nor bad. It's simply a decision about their career. What makes them good or bad is the choices that they will make in their future career as a lawyer, who they will support, who they will work for, who they will defend. However, another group chooses this profession in Turkey because of the injustices they have witnessed throughout their lives and their anger over the pain they have observed. These people say, I will become a lawyer and I will defend those who are suffering under the ongoing injustice. I will fight so that the same does not happen again, they say. Of course, each country has its own collective memory of pain and trauma, but today what we observed here, each country also has their own collective struggle and resistance, because we should believe that if there is oppression, there will always be a fight against this oppression. There will always be the struggle of people. So today, this is what we heard here. Today we understood that we have a lot of common stories. Even though we are living in different continents, we are sharing a lot of values. So this is very important for all of us. Yes, today we heard about Mexico. Last year, it was Egypt. Probably next year, it will be another country. And I hope that one day, this day will be a day of celebration. And this is the reason why we are still fighting. And this is the reason why we are still believing in people and people's fight. But there is one unchanging but must change reality. The world is never a safe place for oppressed people, for the poor ones, or for anyone oppressed by patriarchal structures or violence. Therefore, I can claim that at least for my generation in Turkey, that which we had to witness during our childhood and our youth, determined the position we took in our professional life. Now I will share some stories from Turkey, because I hope that you will understand the reasons of Ebru through those stories. Imagine a Kurdish child who was subjected to forced migration, who saw its father, its uncle, or other people in its village being executed by a gunfire. You know this story from your country. That Kurdish child needed to hide under the bed during the nights to be protected from falling bullets. How many nights, I do not know, because this is not my personal experience. I have never experienced, but I imagine how painful it is. And I can only imagine this through the eyes of my other colleagues who have lived through those situations. Think of another child. Its uncle was kidnapped from home at night by armed and masked men. The whole family searched for him in the police stations for days and days. Official information was obtained after 10 days. When they visited him after 10 days, the tall, strong uncle, who could not stand on his feet because of the torture to which he had been subjected. What remains in this little child's memory? Maybe fear remains, as well as the desire to do something against injustice. This child will become a lawyer and will try to prevent others from being tortured. Let us give a name to this child, and let us give a face to this child and call her as Ebru Timtik. This child graduates from the university one day. Her family was full of pride. She will be able to help other people. And as many as other families in Turkey, they assume that as a lawyer, she will be safe. But those cold walls of the courthouses hit her like a slap in the face. You want to submit a petition for your client? You got beaten. You try to present a defense in the courtroom, but your words get interrupted. There comes a moment when you have to occupy the courthouse because you cannot prevent your detained clients from being unlawfully kept at the police station. Of course, you help others, but your mother was not right. You are not at all safe. On the contrary, your profession, or I think in a better way to say this, the way how you are practicing your profession is perceived as a threat to the ones in power, and you are declared as a public enemy. In our case, in Turkey, you are declared as a terrorist. Your client is at the police station. You go and explain her about her legal rights and then leave the police station because you have done what you need to do. Then the next day, that beautiful woman Your client is transferred to the courthouse, but she's covered in blood. Her nose is broken, and you just want to scream. A curfew is announced in Kurdish provinces. You know that there is no legal basis. You decide to travel there to write a report and to observe, to document the situation with your colleagues from abroad. Your only wish is to identify and report about the unlawfulness that has happened there, which takes you 3 days. You, as a lawyer, will listen to detect violations of rights. You listen to the mothers who could not take the bodies of their children who were shot to death. You see the doctors who are prevented from entering the region and who are suffering. The meetings last for hours. In the background of conversations, you hear gunshots from only a kilometer away. When you go back to your safe hotel, so-called, at night, the gunshots, they do not stop. Or you are told that 301 workers died inside the mine because of clear negligence by the owners. You meet with other lawyers from your country and go to the city where the miners live in order to provide the workers' families with legal aid. Afterwards, you are surrounded in the courtyard of the hotel where you are staying, and you have just one question. You ask yourself if you are going to be beaten or burned alive there. And a couple of days later, you got beaten and you are arrested. These are short stories, and I think this is one of the easiest speech that I am making, because I know that people who are sitting in this room, you understand what I am talking about. This is very important. This is very important to know that we understand each other. And I am thankful, I am grateful to Ebru for giving us this chance, because now we are communicating and we know that we are not alone all around the world. After Ebru's death, many of us, especially the ones who know her personally, it was very difficult for us to make proper sentences. For some weeks, we didn't want to mention conventions. We didn't want to mention regulations, laws, protection, etc., because it was very difficult, because we lost one lawyer who was just demanding fair trial, and not just only for herself, for the other people, for thousands of people, 10,000s of people in Turkey who are suffering with the same lack of fair trial principles. So it was really difficult. And I think this is important. This is my responsibility here to underline that Ebru never wanted to be called as a hero. For her, her practice was natural, ordinary, and I think most importantly, it was necessary. It was an obligation for her. She always did what she believed right. So it is important to understand that the aim of the Ebru Timtik Award is not about remembering or praising her, but it is about her struggle. It is about people's struggle, and it is about values. It's about people's rights. This award is not just for saving the life of other Ebrus, but we should all be happy if we can, but for protecting every other person who is suffering under injustices. To prevent torture, to prevent the forced disappearances, to be sure that no other children will have such traumatic memories, to be sure that no one will need to hold a hunger strike for demanding fair trial. This is the aim of this award. I hope that today will give us at least a strong hope for the future. And I will finish with Ebru's words, because I know that if she would be here, she will finish her speech with this word, like many other colleagues from Turkey. So I'm borrowing this. We should all believe we are right and we will win one day. Thank you.
Garan, thank you so much for sharing more about the story of Ebru, putting it in the broader legal context of Turkey. And we are particularly grateful because, you know, we know how hard it is also for you to tell this story every time, but how you feel it's important. And in a world where prejudice, corruption, inequalities, organized crime, as Diego was saying, sometimes seems to be overshadowing the pursuit of justice, the individuals that we honor today, they really do stand out as beacons of integrity. And they serve as an inspiration, even though Ebru didn't want to be referred to as a hero. Through this award, what we really want to do is to recognize and amplify the voices of those who stand up for justice, for equality, and for fairness in the really most substantive meaning of the term. And in this regard, in the steering group, we also believe in the transformative power that art can have in raising awareness and inspiring, igniting change. And this is why every year, through the advice of a curator, a New York-based curator named Ishin Onol, that I would like to thank for her support to the initiative, every year we identify a different artist that has a specific sensibility to human rights and is willing to cooperate with us to create a piece of art that is really dedicated to the Ebru Timtik Award. And even though the piece of art is dedicated to the winners of the awards, ultimately, it will remain within the International Fair Trial Day, because our ambition, our joint dream further down the line would be to have a physical space where we can have a permanent exhibition of all the art pieces that were created year after year for the awardees of the Ebru Timtik Award. And before we proceed, I would like to draw your attention to the art piece that we can see here on the left side, next to Diego. And it has been created specifically for this year Ebru Timtik Award. And next to it, you can see some glass prizes that are handled every year to the awardee of the award. And so at this point, I would like to introduce the artist behind the piece of art. She's Mirta Kupfernic, connected online. And she's an international award-winning artist, teacher, and curator. She was born in Buenos Aires to immigrant parents who had survived Auschwitz. So therefore, identity, human rights, memory are themes that run through her work. And since 1997, she has had over 100 solo international exhibitions, and her artworks are showcased in many of the most important museums and institutions all over the world, literally from Washington to Jerusalem to Taipei. And in 2015, she launched the LABA, the Laboratory of Art and Jewish Culture in Buenos Aires. I think we have her on Zoom, connected from New York. And so now I would like to give the floor to Mirta. It would be wonderful if she could tell us more about the creative process behind this year Ebru Timtik Award art piece.
Buenas noches, muchísimas gracias. Buenas noches, buenas tardes.
Good night, good afternoon, everyone. Thank you so much. Thank you, Rosie Lasso, and all the hosts of this event and this fight of our struggles. And I'm really thrilled. I feel very emotional and honored for having been invited. Thank you so much, because I believe and I'm convinced about what's factual here, what's important. I know it's important to include in this type of fight or struggle, we have to include art. Art has the power. We can say things through art. We can say things through it and paraphrase it, so we can communicate the message, send it across through art to people that would have not even approached the message because they're not personally linked to a determined cause. And art can achieve that, it can bridge. But personally, as it's been explained by Eleonora, she explained that my personal story, I'm the daughter of survivors from Auschwitz, and I was born in Argentina. I have my story. We've gone through dark stages, and that made me raise awareness as an artist. I know that I'm responsible from wherever I work as an artist. Now I'm gonna describe to you what I wanted to communicate or do with this art for the Ebru Timtik with this award. You see the paintings, it's all handmade with art. that's unfolded, that leads us to glance and look at the book that glances back. So it's all connected. With the images, we have texts. We have the first article of the Universal Declaration on Human Rights. We have that article that's written in Spanish and in English. And in this piece, there's 2 pages in which you're going to find the article written in Kurdish and Turkish. So I decided to write this text by hand. So I used my body to write, and I take that past to this present. You know, it's an action that raises mindfulness and awareness and a reverence and respect to that higher consciousness. Now, so before I conclude, I'd like to thank you very much. And I'll quote Picasso. You know, art is art and paintings and shapes printed on that paper. But Picasso said, and I quote, art could be a lie. Art is a lie that helps us unveil and say the truth. So thank you all very much. Mirta, thank you.
Thank you also for fully embracing the message behind the Ebru Timtik Award, especially a message of universality, as you have explained. And this is the very reason why we are here this afternoon, celebrating Mexican individuals and organizations through an award that bears the name of a Turkish lawyer. And so now I think it's about time to introduce the remarkable and independent jury that went through the nominations and that was tasked with the very insidious duty of having to shortlist this year's awardee. The jury was made up of different professionals. Their full bios can be found at the end of our long program. I can briefly introduce them. Alejandra Manavella, Costa Rican lawyer, specialized in criminology and serving as advocacy coordinator for the Mesoamerican program of the Center for Justice and International Law. Arturo Furner Pasio, that among other roles served as ambassador of Costa Rica to the Russian Federation. In 2022, was elected Costa Rica's representative to the board of directors of the American Association of Jurists, and in 2023, appointed as member of the scientific committee of the Monique and Roland Will People's Academy of International Law. Then another member of the jury, Evgenia Kuniaki, whom we have the pleasure of having with us today among the audience, lawyer and anthropologist from Greece. She represented throughout her career and in many landmark cases, victims of police and of racist and extreme right-wing violence. And she has worked in NGOs with NGOs involved in defending the rights of migrants, of refugees, and documenting human rights violations at the Evros border. Then a name that came up many times during today's panels, Lucha Estela Castro Rodriguez. I don't think she deserves further introduction at this point. Mexican feminist, lawyer, human rights defender. For more than 35 years, she represented victims of human rights violations like feminicide, trafficking, torture, forced disappearances, family and sexual violence, displaced person, defenders at risk. I want to highlight that Lucha was very sorry not to be able to join us today. She recorded a video message to comment on the jury's decision. The video message will be published on our International Fair Trial Day website. And after the conference, I encourage you to go to the website and give a look at it. And finally, I would like to introduce Iris Rocho Santillan Ramirez, whom we have the pleasure of having us today on this panel representing the jury. Lawyer and feminist criminologist. For more than 18 years, she worked in the field of law enforcement. And for the last 22 years, she has been dedicated to teaching and research in the field of violence against women. She lectured in various forums in Mexico and abroad and published many articles of book. And she was part of the working group for the activation of the first gender violence alert in Mexico. She's currently a full professor and researcher at the UAM University, where her work focuses on gender studies and violence against women. And it is my pleasure now to give the floor to Iris for her to announce the decision of the jury.
Buenas tardes a todas, a todos.
Well, good afternoon, everyone. For me, it's a pleasure. I feel very happy and grateful for being part of this expert panel along with Mr. Diego Leonora Iseren. I'm very glad to be part of this important event. We're honoring the life of Ebru Timtik. I was appointed by my colleagues in the jury to, I'm here in Mexico, but I was appointed to be here because I'm based in Mexico and I feel honored. So amongst all five of us, we drafted this instrument that I'm going to read now. Distinguished and honorable representatives of different national and international agencies that fight for human rights, members of the collegiate committee that's hosting this event and the International Fair Trial Day of 2023, in which we're celebrating Ebru Timtik. We're working for those victims that have their rights being violated. And thank you all stakeholders for being present. I'm Iris Santoya, an attorney, criminologist, and feminist, scholar from National Autonomous or Metropolitan University. I'm honored to speak on behalf of those who are integrating the jury for the third edition in which we celebrate Ms. Ebru Timtik. Luz Estela Castro Rodriguez, well known as Ms. Lucha Castro, defendant, Mexican defendant. Arturo Fournier Facio, Costa Rican lawyer, attorney that represents the International Association of Democratic Jurists. Alejandra Manadela Suarez, defendant of human rights, representative of the Justice Center in International Associations called CEGIL, and Eugenia Kounyaki, who is a Greek anthropologist that's a defender of migrant people. To celebrate and give the award Ebru Timtik, we have considered the value of Ms. Ebru Timtik, attorney from Kurdish origin, defendant of human rights, who was wrongfully incarcerated for the hard work she materialized defending the vulnerable people that live under oppression due to economic conditions, ethnic backgrounds, and nationality. Ms. Ebru Timtik dedicated her professional life to defend the exploited, the vulnerable. And she was detained unjustly with her members who are part of the Association of Progressive Bars and Lawyers. She was beaten, tortured repeatedly. Her process wasn't fair. She didn't have access to a fair trial. After 238 days in that hunger strike, she demanded to have access to a fair trial. Ms. Ebru Timtik passed away. As part of the jury that fights to continue passing on the voice of Ebru Timtik, we award this token to those who honor justice and fight for fair trial, the defense for human rights. Those are the criteria, and we're here to defend the vulnerable people. So we had to elect the winner, and to elect the winner wasn't easy. In Mexico and LATAM, there is a great number of violations of our human rights that are committed daily. There's torture, forced disappearance, feminicide, human trafficking with sexual exploitation, labor exploitation, migration, corruption, and impunity, amongst many other problems. This affects the life of us historically, and there's many people that have been long forgotten and discriminated. The hard work of these people that fight to protect people in context of violence leads us to analyze the context. Not all people are willing to be defended, so that's why it's so important to honor the hard work of all the people, associations, and entities that were submitted to be awarded this prize. Fray Bartolomé de las Casas Human Rights Center, that's called FRAIBA, the consortium called Oaxaca Consortium. Those are the nominees: Arredondo, Anayeli Perez Garrido, and Alicia de los Rios Medina. The FRAIBA Center has worked for 34 years constantly. They're fighting for the indigenous population's rights in Chiapas, in Mexico, to make our indigenous populations visible. Their file claims when there's human rights violations that unjustly lead us to analyze the situation of the accused. This center continues in a sustained way to try to have access to a fair trial. We acknowledge the hard work of this center. And they're working to impose the independent process with the municipal authorities, along with other entities like the Zapatista groups. It's clear and evident because of what we saw with because there was attacks towards the Mueces Candy community. Mueces Oaxaca is a feminist association that's been working for 19 years and they've been fighting for equal rights and human rights They're female defendants, and their objective is to have an impact on the legislation process and in the drafting of public policy. They want to foster and articulate the proper citizenship network and provide training for women so they can understand and know that they have rights. They're there to support and build a citizenship that's active and participates so they can have access to democracy, social inclusion. Mr. Francisco González Arredondo was also nominated prosecutor, anti-corruption prosecutor. He was the lead of the prosecutor's office in the research area that fights violations for human rights. His leadership in his fight against corruption and impunity has led him to constitute a multidisciplinary group without precedent in this country. This collegiate body starts investigating criminal cases, and due to embezzlement of former government officials, association to criminal cells, and embezzlement due to activities in organized crime. So he also analyzed the unlawful use of the criminal codes, and he has been reivindicated and he was taken into custody due to political issues. His case, or Mr. Arredondo's case, sheds light on the criminal or the abuse of the apparatus, and his fight strengthens the rule of law, taking us to move this towards steps forward to fight corruption. Ms. Medino is a historian, lawyer in the field of forced disappearances in Mexico. Her mother was disappeared during the 70s. She is an attorney, was not only a victim, she decided to work in research and engage and commit herself to support those who have been disappeared or whose people has been disappeared. She has been working since 2002 in 7 cases before the general attorney or the prosecutor of the country. Ms. Perez Garrido is a main attorney of the Citizen Observatory of Feminicide Watch. She's the lead of that observatory, and she's an attorney that has been engaged with activists and defendants that are also part of civil organizations that have been constituted in the struggle. They are located in many entities of the Republic. They have 43 representative offices, and they've worked to support feminicide victims. Now, for the fair trial causes, I mean, we know that these associations have been part of it. So to decide or rule or issue a verdict about who was going to win this award, I mean, it's been very difficult. The jury has submitted its verdict, so we've decided to award 2 stakeholders. Alicia de los Ríos Medina receives this award, and Analisa Perez Garrido receives the Ebru Timtik award as well.
Creemos merecedora de este
We
premio.
believe that you, Alicia, you deserve this award, ma'am. You're here with us, and we know that you've been looking for your mom, searching for her, and your reference point. You have other people or relatives that are still trying to find their family members. She was part of an entity called Eureka. It's a collective that's been constituted and fights in Mexico that's been constituted by family members that it's a collegiate body that finds or tries to find their mothers and those who have been forcefully disappeared or who have forcefully disappeared. I mean, they're representing over 100,000 people that have disappeared in Mexico too. This collegiate entity has triggered the Mexican government to constitute the Commission for Truth. She's a seeker, she's a pillar, she gives us hope. Her dissertation to achieve her PhD leads us to continue analyzing the context. There's insurgency in Mexico that happened in the 60s and between the 60s and to the 90s. So on the other hand, this award acknowledges the great effort of Anayeli, and it's extremely relevant in a country where the levels of violence against women because of gender does impact, and it impacts, and it leads us to analyze homicides, violent deaths. Many of these cases are left in impunity due to a patriarchal justice system. Her work is always under risk. There's grave violations of human rights that have been made public. She's pointing out the individual perpetrators as well as the Mexican government. She has been for us and for our colleagues, in our jury. We know what she's been done, where all these associations and people have done, all the nominees. I'm certain that all the nominees could have been, we could have had a greater list of nominees. So as gratitude, we acknowledge all their hard work. We acknowledge them. We acknowledge the hard work through them, the hard work of other people that are working to build a fairer country or planet, just like Ms. Ebru Timtik. She fought her struggles with dignity to have access to fair trials. So they're on the good side of history. Let's cast our votes. And this event should echo the infinite voice of Ebru Timtik. We should never forget, and we should continue her struggle until her last breath. Thank you so much.
And I would invite Alicia to come here in front of the stage so she can receive the award by Diego. And Alicia, if you want to say a few words.
Buenas tardes a todas, a todos.
Good afternoon, everyone. Good afternoon, everyone. It's included. So I'll briefly thank the Association of Progressive Attorneys here. I thank Sarah, and I thank Eleonora, I thank Barbara, I thank Carolina, and of course, I thank the hosts in the nation or the country, the host country. And I thank you once again for having included me in the nomination, for receiving this award. And thank you for awarding me. I had never been nominated as a candidate to receive such a prize or an acknowledgement. Sarah, you were talking about what happened with Miss Ebru. And I was thinking and saying that I consider myself just a girl. I'm just a girl. And after 46 years, I've tried to find my mother with all the tools as an attorney, historian, and as a part of collective entities. So today I received this award, knowing that this is sourced, or this is a product of a major process of events that's been triggered by my passions. Ebru, I thank Ebru for giving an example of dignity before autocratic models. Thank you so much. Thank you for supporting. Thank you all for being here. Thank you for being present. We thank the Pro Center as well as an entity. We thank SEDEM as an entity. We thank FADEM. We thank Mr. Tita Radilla, Alben Gavino Gomez. We thank all the stakeholders. I thank Ms. Lucha Castro and other agencies, associations, collegiate bodies constituted by friends and family members. I thank our friends, colleagues who have become part of the critical voices that echo, trying to explain the horrors that we live in this country. But we're also echoing the voice of hope. Your voices are the sustain, the grounds of this litigation and my search of our mothers, my mother, and the struggle in our search. I thank Ms. Marcela Turati, Mr. Camilo Vicente, Mr. Jerónimo Monroy, David Barrios, and Vicente Moctezuma. For César Contreras, for Alejandra Elguero, for Santiago Aguirre, and for all the rest of the team that works in the Pro Center, I send you my love, my gratitude, always. Thank you for fulfilling your promise. I know that you promised to do even the impossible to achieve, to reach clarity and to find truth and to have access to that fair trial. But overall, this award, this acknowledgement is for those people like me who have become seekers, who have become defendants. I thank those over 110,000 people that have gone missing. I thank the search center with my mother, Alicia. We're seeking for those who have disappeared until we find them, colleagues, until we find them. We'll continue. Thank you.
And then we would like to invite as well Anna, Jenny, to the floor is yours again to No, we can please handle the. We are honored to handle you the Ebru Timtik Award for 2023. And we would be equally honored if you'd like to say a few words.
Preparé unas palabras un poquito
Well,
más largas.
I have a longer speech, but it's an honor for me to share this award with Alicia. We're here present, and I know that there's different stakeholders that have had their own struggles, like Mestita Radilla, like many other defendants of human rights. So I want to thank you for honoring me and awarding me. I'd like to thank the jury, the steering committee, the board, or those who are driving this forward. And we're all fighting for an international access to fair trial. And Ebru Timtik. Iris, thank you for being part of the jury. Thank you for your kind words. As part of this election process, I thank you. I salute all the participants, all the keynote speakers, panel members who have been with us today, who are present, family members and survivors of human rights violations who are here, colleagues, counterparts, friends, defendants of human rights. Thank you for being part of UNAM. That's also my home. As I specified in my response email, I've been awarded this prize that has celebrated the life of a woman that shed some light on the factual violation of human rights, as Ebru Timtik did in Turkey. So for me, this is a great responsibility. Since I was a child, I wanted to become an attorney, and my family, we didn't have many professionals, but thanks to the hard effort of my family, I became part of this public entity or university, and I was privileged because I lived here in Mexico City and I had the opportunity to become who I am. So I remember news that were announced back in 2001, and my father was worried because Digna Ochoa had been gunned down. I was to become an attorney, and I was going to become a human rights attorney and defendant. I didn't have that clear at the beginning, but they weren't mistaken. There's many women that I have as reference as a professional, but I want to mention my professors in my struggle and my fight. First of all, I want to mention Maria de la Luz Estrada, who has been a woman that's responsible for who I've become today. She's a professor, friend, co-author of many of my achievements, important achievements. She's a defendant of women's rights, and that's why I'm here today. I thank Ms. Lucha Castro. I had heard of her activism before I got to know her because she was an attorney, and then I got to meet her, and I had discussed with her many things in the Feminicide Observatory. I got to know Lucha years later when I was in a few days visiting Chihuahua. Lucha had not had the opportunity to go to a morning session. She was trying to find refuge for indigenous populations that have been an object of displacement. They left the Sierra, the mountain ridge, because drug cartels were affecting them. So they were trying to fight forced disappearance cases, and the prosecutor in that case had or tried to cover the participation in the crime of the municipal authorities. She had a public hearing in that afternoon. Another professor of mine is Marta Figueroa. She's always been taking care of her counterparts, peers. She's always taken care of other women, indigenous or mestizo populations. She's always giving us her love and coffee, sending it from Chiapas, or making fun or facing the patriarchy, the military and the police forces. These are strong women, and I'm aware of their battles. I've learned so much through them. I'm fearless, and I've become fearless and intelligent and brave. I built strategies with a strong voice that fights injustice. I can face the army, a prosecutor, or any or governors, whoever it might be. I speak on behalf of the women who are defendants in the country because there's structural violations in different levels exercised just because we're women, but we still have strength to defend others. And that's why we can see the faces of the mothers, victims of feminicide, and mothers who are still seeking for their loved ones, and a great number of activists and human rights defendants that are here. Even if they haven't lost a relative or a family member, they're still fighting to dignify our citizenship, demanding justice and the respect for due process, due trial under the principle of fairness. The victims and different parties have rights. I've been serving for years as a defendant. I've had great colleagues, counterparts, teachers that work for different NGOs or civil association entities, collegiate bodies as the observatory. That's an entity that's feminists. It's a feminist observatory. Here, there's many professionals that are fighting for human rights, attorneys that are completely engaged as professionals. Their profession is the ideal tool to fight impunity and promote the proper democratic rule of law that we fight for and want. Sometimes we think that our achievements are just a few, but if we compare our achievements with the reality or the terrible reality that we live in our country, we know that the quality of the service and justice administration is collapsing in Mexico. But we document the cases and accumulate cases that are filed in which there are terrible human rights violations that happen on a day-to-day basis that are left in a stance of impunity. Rosendo Radilla Pacheco is a case that represents thousands of people that have disappeared with a war in Mexico. Ms. Tita Radilla is part of her hopes. Her mother, Claude Libet, Esmeralda, Laura Benenice, are these girls that were found in the cotton field. Rubí, Maricel Escobedo, Carla, Mariana, Yvette Melissa, Paloma, Nadia Alejandra, Ali, Rosa Diana, Evelyn, Jan, Campira, Fatima, Maite, Abigail, Cianya, Leslie Berlin, and all the stakeholders that I haven't mentioned. They're just some of the names that have been subject of violence that's generally imposed into women and children. That's a maximum expression. There's names that I could not read. I mean, there's a great number of families, over 3,000 cases, over 4,000 girls and women have been slaughtered or murdered yearly in this country. Consider the survivors of feminicide, and justice is taken away from us and from them. Valentina Rosendo, Inés Fernandez, they are friends from Atenco. We echo the voices of their fight and resistance against misogynistic violence exercised. The Familia Alvarado and the cases of the 43 Ayotzinapa professors are just files that quantify the atrocious violations of human rights in a country with over 1,100 people that have been disappeared. If we quantify the numbers till yesterday, there's graveyards in which the people have tried to dig in, or in which they have used our land to simply disappear our people. So this makes us become mindful. We are working to guarantee the due process, a fair trial. That's what we call the new criminal justice system, or the adversarial system. And these cases that are cases of reference, they're the highlights, and they unveil the reality in our problems to the core, irrespective of their nature or the cause. There's structural discrimination exercised against women in the public and private arena. The state is repressing, and organized crime does the same. There's malfunctions and gaps in the administration of justice, and where the principles should hold us accountable. They're the pillar of the backbone that leads us to materialize justice and the proper rule of law and fairness, what we aspire to achieve as societies. And mentioning as reference during your mandate, sir, you as a panel member, you're the ex-rapporteur, the special rapporteur of independence from the justices. Mr. Sayan said in his executive report what describes Mexico, the national context has been authoritarian when they're exercise their power. There's international networks of organized crime that are corrupt and are tacit or manifested because the judiciary branch is not autonomous, and they affect the main rights or the principal rights of the population. So there's setbacks in our struggle to fight to protect our women's rights and our people's rights. So that is the impact of organized crime. There's attacks being materialized against the defendants and activists. The autonomy from the judiciary branch and exercising your license as an attorney affects us all, and it affects all our vulnerable groups. This has been mentioned by our rapporteur, sourced from Mexico, and we see the full dimension of it. A few weeks ago, there was a video distributed in which there's an execution materialized by members of the military that happened on May 18th, 2023. In the comments of that video that was streamed, the majority of the people, almost the totality of the comments, congratulated the army or the military. It's understandable that the population is angry, that the population is frustrated when there's violence at this level, when there's impunity and organized crime parades through the cities and populations with their vehicles, with long weapons, shoulder weapons, as a symbol of control and taking over power. But when the state enables criminals to take over society, and the state exercises violence too to try to recover control, there's a lack of rule of law, and that's what's happening in this country. This is why today, more than ever, as professionals who exercise our license in law, we have responsibilities. We're working to reorder and restructure the harmony in our society to make the rule of law be material in all layers. With a vision and the positive law, we're working with a new constitutional trends or doctrines with a base of reasoning. The principles guide us. We analyze cases with gender perspective. We develop our levels of expertise under the principles that guide us and bind us to achieve fair trials. But it's not just that layer in which we administrate justice. We have the challenge. And what challenges are we facing? There's the rights of indigenous populations and other sectors. The rights or law should be of public domain that leads us to justice, to eliminate institutional violence. So we want to strengthen the apparatus, the institutions, so that could guide us to the proper rule of law. Rights and law are not for the elite, it's for the population. So we need to rebuild society and the administration of justice under the democratic model. We need to give that response back to strengthen justice and to fight answers to the crimes committed in the past in our history. We have to eliminate the structural injustice through the system that we currently have. We need to redefine the legal framework, the legislation, to find the transition for justice tomorrow. In this rule of law, if we don't fight for that democracy, we're fighting to achieve that. So we're responsible. I manifest my commitment as a defendant of fair trials, human rights, and the due process. Thank you so much.
But the Ebru Timtik ceremony doesn't end here, because only for this year, it was a decision of our jury to also handle certificates of recognition to the other nominees whose work for the advancement of fair trial rights has been particularly remarkable. And some of them are connected online, like Francisco González Arredondo, and they will receive the certificate via email. But we are lucky enough to have representative of the other two organizations here in the room with us. And one of them is Dora Roblero García, the director of the Centro de Derechos Humanos Fray Bartolomé de las Casas, FRAIBA. And I would invite her to stand up, and my colleague Sophie Larocque will handle her the certificate of recognition.
We are not alone. We are not alone, although we are missing a lot of us.
And at the same time, we also have a representative from the Consorcio Oaxaca here in the room, Jessica Sanchez. And we are very honored to handle a certificate of recognition to their incredible work as well. Thank you. And as a final note, I would like to Tonight's ceremony was a reminder, and is a reminder, that fair trial is not just an abstract procedural law concept. It is really a fundamental pillar of our democratic societies. And it is a promise to every individual that they will be treated fairly and their voices will be heard in the pursuit of justice. And in the faces of the abuses and the oppression that we often witness in our human rights work, it's easy to lose hope. And the individuals that we are honoring tonight, they remind us that hope can be found in the resilience of the human spirit and in their unwavering commitment to the principles of human rights. And so the awards that we presented tonight, they symbolize a testament to the power of individual action and a call for all of us to be champions of fair trial rights, of fair administration of justice in our own spheres of influence. It's a work far from over, and together we must continue to advocate, to raise awareness, to demand accountability, and to ensure that protection and promotion of human rights remains at the forefront of our collective efforts. And on this note, I would like to close the Ebru Timtik ceremony and invite my colleague Ayşe Bingöl to the panel to give some closing remarks.
It is not easy to follow such a beautiful ceremony that has been so touching for us all. I will try to keep my closing remarks as brief as possible. Our distinguished speakers, guests, Ebru Timtik Award recipients, nominees, and in-person and online participants. We came together today to side with the human rights community in Mexico and support their struggle for human rights, particularly in their efforts for recognition and promotion of the right to a fair trial. People have joined us for this purpose from different regions in Mexico, as well as from Colombia, Panama, Peru, Argentina, USA, Italy, UK, Greece, and France, among many other countries. We have people who have followed us online from across the world. We have all been here to hear about Mexico, the deep-rooted systemic fair trial issues in the country, and how these issues are strongly linked to the general human rights situation and political atmosphere in the country, in the region, and globally. The interconnection between these different elements and the similarity between different contexts is striking. Like many other countries where the systemic human rights issues are acute, including, for example, enforced disappearances, violence against women, systemic torture, incommunicado detention, oppression of dissenting voices, and discrimination against disadvantaged groups, including indigenous people, we see a corresponding judicial system that profoundly fails or is made to fail to function properly. In such context, the judiciary does fail to protect those whose rights are brutally violated. It's turned into a tool to stifle dissent for political purposes, to deter others, to punish or further rights violations. It's used to create a shield of impunity, as we have heard today. In the dark court corridors, people who seek justice, accountability, and truth are forced to lose their faith, root, and determination. Well, not people like Valentina, Marta, Alicia, Anayeli, Tita, Ebru, and many others who are here today or following us today. As we heard striking examples of it today, the impact of human rights violations is doubled, if not more, in failed judicial systems, leaving people unprotected, with no remedy to resort to against injustices they face. This not only leaves those who seek justice in further turmoil, but it also allows continuance of the violations against them and many others. Without a properly functioning judicial system that must inherit a full adherence to fair trial standards, full implementation of a country's international human rights obligations is not possible. Throughout the discussions today with Madam Commissioner, Mr. Garcia Sayan, and other speakers, we heard a further aspect of these failed judicial systems, that there is a systemic failure to implement the decisions or judgments of oversight mechanisms that the countries are bound to implement. Examples include the Inter-American Commissions and courts' deliberations about systemic human rights violations in Mexico and other countries in the region, an issue we don't only see in the Inter-American context, but also in the European Court of Human Rights context as well. Together with the reflections of our prominent speakers around these issues, we also heard their views on the difficult question of how to resolve these issues and how to ensure that the justice system in Mexico is in full compliance with the international fair trial rights standards. While answers to this question are not easy, we can all agree that all challenges mentioned here today cannot be addressed without political will. In other words, there needs to be a political atmosphere that is in favor of a change. People need to demand change. There must be a democratic system that will allow the change, a government that will take robust steps to facilitate the change, and willing members of the justice system to implement the change. We hope that thanks to its vibrant, determined, and brave human rights community, Mexico will achieve bringing together all these components, which will hopefully pave the way for other countries in the region and beyond as well. As my fellow steering group members underlined throughout the conference, the International Fair Trial Day and Ebru Timtik Award organizing committee comprise a number of bar associations, international and regional bar associations alliances, lawyers, and human rights organizations. Our colleague Ebru Timtik inspired this initiative. This year we observed the third year in Mexico. We are honored to be among you today and having had the opportunity to contribute in our humble way to your struggle in Mexico. We are confident that this event in Mexico will encourage more to focus on the fair trial rights issues in the country, to get involved in the struggle of human rights defenders, and to give them more voice, which will hopefully be heard by more. This in turn will give us more motivation to continue our work and in the coming years focus on due process rights challenges in other contexts. After the event today, we will work on a short report, which will include the main discussion points throughout the panels today and recommendations. Please be on the lookout for a draft that we will be circulating with you. On these notes, I would like to finish my closing remarks with a few thanks that are due. We would like to share our sincere thanks to UNAM and the technical support team of UNAM who hosted the event today. We would like to thank our Mexican bar colleagues, especially Incam, Arturo, and Adriana. They are here today, and they have been a great support. Without them and our Mexican bar colleagues, we would have been so much difficulty to host the event today. Thanks are also due to Madam Commissioner Judge Garcia Sayan for being here in person and contributing to the conference with your incredible wisdom, experience, and expertise about the region and globally, despite your very busy schedules. To President Ricardo Perez and Special Rapporteur Margaret Startwaite for their video interventions as well. We are grateful to our moderators, our speakers, for making the efforts and joining us in person today, for sharing not only their views, your views, which have been shaped around your professional activities or activism, but also your personal stories that will leave lasting marks in our hearts and in our minds. Special thanks are also due for Mirta Kupfermic, the artist of the artwork that we presented today, and also Işın Önal, who advised us throughout that process. Alicia and Anna Yeli, this year's Ebru Timtik Award winners. Your journeys in the defense of human rights, seeking truth and justice have been an inspiration to us, like many others. We are thankful and grateful for all your dedication and sacrifice. We hope that this award will give you a bit of more brightness to the torch that you are carrying and courage to continue your struggle. And we thank our Ebru Timtik Award jury, Alejandra, Arturo Fournier, Evgenia, Iris, Lucha. We know that they faced the very difficult task of making a hard decision, and thank you for doing it so beautifully and gently. Lastly, I would like to thank, on behalf of the steering committee of International Fair Trial Day and Ebru Timtik Award, the human rights community of Mexico, to name some women rights defenders, indigenous people, lawyers, journalists, and academics. Your struggle and work inspired us deeply and have led us all to be here today. We hope to see you and share the same platforms with you soon again, but hopefully in the better days of the future. And of course, the interpreters today who has been doing great job for a long and a difficult event. We appreciate them being with us, bearing with us today. Thank you very much.
And if everyone from the audience wants to come here in front, we can take a group picture to have a memory of this important day.